Okay, it is 10 a.m. on the 10th of April, 2023. I hope everybody, wow, that's pretty loud. Maybe you might want to turn that down just a little bit. But we're getting some feedback there too. So anyways, I hope everybody had a nice Easter holiday yesterday. And so at this time, I call to order the Douglas County Board of County Commissioners special meeting for April 10th, 2023, and ask you to all please rise for the Pledge of Allegiance to be led by Commissioner Charlotte Hales. Wherever State Assemblyman Ken Gray is, if that eagle on that flag is turned to the rear, he corrects that. So I don't see him here, so I took the opportunity to do it myself. But anyways, we will go into public comment. Public comment is limited to 3 minutes per speaker unless additional time is granted by the board chairperson. The Board of Commissioners uses timing lights to ensure that everyone has an opportunity to speak. You will see a green light when you begin, and then a yellow light which indicates you have 30 seconds left and should conclude your comments. Once the light turns red, we ask you to please sit down. In addition to opening public comment will also be taken on administrative agenda items that are identified for possible action, of which we only have one today. If you plan to speak on a specific agenda item, so if you wish to speak on that item that is on that agenda and identified for possible action, then please provide your public comment when that agenda item is heard. We are required by Nevada revised statutes to take 2 periods of public comment per meeting. We will be taking an opening public comment, and we'll take public comment after the board reviews this presentation by the VHR manager, Ernie Strelo, and allow the commissioners to weigh in on their feelings about each of those issues, after which time we will then entertain public comment after we've concluded our discussions, and we will not have any closing public comment after that point in time. At this time, public comment will be taken on those items that are within the jurisdiction and control of the Board of County Commissioners. We ask you to please approach the podium, print your name, state your name. For the record, your time will begin after you state your name. So at this time, the floor is open to public comment. And we ask you to go ahead and line up so we can move through this as rapidly as possible. If you share the sentiments of the previous speakers, it's quite okay to say ditto. And even though public comment is allowed for 3 minutes, you're not required to take 3 minutes either. So, okay, with that, public comment.
Hello, my name is Bob Poet. I am a over 40-year resident at in South Lake Tahoe. I'm a homeowner, but I do not use my property as a VHR. However, I would like to have the freedom to do that if I choose. I'm a realtor here in Nevada, also licensed in California, but I'm here only as a citizen right now and speaking only for myself. I'm not a property manager. So I have 3 freedoms that I'd like to address and 3 challenges that I'd like to issue. First freedom to use my property as I choose. Second freedom, when I'm out of town. My wife and I have stayed in motels and hotels and with relatives, but we also like to be able to rent a vacation home rental, and we've been able to do that in the past. I'd like to keep that freedom. Third freedom is freedom of a good night's sleep. All right, so there's got to be some balance there. The challenges. I issue a challenge now to the homeowners, and this is going to be a challenge, I know, because it's been a rough winter on everybody. Increase your deposits. Increase them. Double them. double the deposits, you'll edit out right there a lot of the bad actors. Because it's the bad actors who should pay, not the homeowners, not the neighbors. Who's making the noise? It's the bad actors. So stick it to them, evict them, and I know it's not going to be easy, but you know what? That's the challenge. Do that. Second, to the neighbors. I'm a neighbor. I live next to and close to vacation home rentals. I've seen firsthand it's the right way to do it, wrong way to do it. Just today, I called the right way to do it, people, and I thanked them. I said, thank you for these people who were here over the holiday. They were nice. They had a good time, it appears. I didn't talk to them or engage them except to wave at them one time. Encourage those people to come back. And you know what he said? These were repeat customers. That's exactly what you want. You get 52 of those, you got 52 weekends of peace and quiet and good night's sleep. That's your goal, okay? The neighbors, do that. So for every complaint, because you got to do those too, but call them on the good guys too. Third one, for the council, for all of you, I want to first, in that spirit, I want to thank you for making a couple of corrections. One on like 32, where you've put a cap on the amount of fines to $20,000. I think before that was the total value of the house. Well, criminy, that's confiscatory, right? So you fixed that. Thank you for that. What was the other thing you did that I liked? Damn it, I can't remember. But I don't see any lights here either. Is it 2 minutes, 3 minutes yet? 4 seconds? Okay, we'll leave it at that. Thank you for that. Keep it simple. Keep it simple. Make it easier for people to put their house on the VHR rolls. Thank you.
Thank you. Did I mention to please silence your electronic devices? I don't know if I did or not. So, appreciate it.
Good morning, Ellie Waller. Before we begin today, I sincerely hope all board members should show equal respect for the differences of opinion and the comments brought forth by the members of the public. At several meetings I've recently attended, I experienced varying degrees of lack of decorum. There are many examples. Here are just a few. There are board chairs that should be leading meetings without excessive rude interruptions. And clearly at the Regional Transportation Committee last Friday, a very disturbing, profane-laced conversation about me took place between two board members, and one didn't even know me. That inflammatory banter is unacceptable behavior and should have consequences. You're not alone. At a recent TRPA meeting, the California governor's representative called a bunch of us the vocal minority. Very disrespectful. Let's be clear, this continued poor behavior and the treatment of the public must stop, and facts, not suppositions or assumptions, must rise to the level of competence of our elected and appointed commissioners. All in attendance should thank the VHR board members, staff, the DA's office, law enforcement, and fire department for weathering this arduous task. Their fortitude and decorum are much appreciated. Not many people volunteer for tasks like this, require them to give up personal time on behalf of the betterment of all of us. My observation as a public participant for many months at the vacation home rental meetings, which included Tier 3 approvals, denials, appeals, and revocations, as well as numerous meetings on these code amendments. There were a variety of participants of these various meetings, and comments came from VHR owners that live in Nevada, VHR owners that live out of state, residential owners living next door nearby with complaints, residential owners living next door with no complaints, VHR owners that want no rules, VHR owners that embrace the new package in totality, residents that do not want any VHRs, and residents that want stricter rules. The Planning and Board of County Commissioner recommendations at various times have been taken into consideration. The amendment package before you today was a monumental task and a culmination of all these different aspects and more. There is no perfect fit for any one category, but this is the first in many updates that will come forward in the years to come to this board and future boards. Thank you, Jennifer Davidson, Sam Taylor, no longer with this team, Tom Delaire, Mickey, Lauren, Patty, Keith, and Michael, no longer with the team, along with Ernie, staff, AJ, the fire and sheriff representatives. I urge the board today to embrace this amendment package and make very few changes, if any, so the amendment can be moved forward and time tested. Thank you.
Good morning. My name is Jeannie Kerner. Good morning, Chair Gardner and Commissioners. I'm a 37-year resident of Douglas County, a business owner, and the immediate past president of Sierra Nevada Realtors. Sierra Nevada Realtors supports reasonable restrictions to vacation home rentals in our communities. We believe the proposed amended ordinance raises new concerns and impairs a fundamental right of private property ownership. The proposed ordinance changes do not only impact private property rights, but could also impact the real estate economy in Douglas County. We believe the current iteration of the VHR ordinance is working as intended, and the proposed changes create more confusing, overbearing regulations for property owners to understand and comply with. As we did with the Planning Commission last month, we would like to point out a few concerns. The proposed 12-month waiting period for a new owner to apply for a permit creates an undue burden on the homeowner to adhere to, and it also impacts a buyer utilizing the federal 1031 tax exchange program to purchase a like property in Douglas County. We learned from previous VHR restrictions that not issuing permits to new buyers leads to several homes falling out of escrow and impacting the county's economy almost immediately. Thankfully, the Planning Commission agrees to and voted to strike that language from the amendments, and we respectfully ask that you uphold their motion. Sierra Nevada Realtors supports existing occupancy language allowing for 2 per bedroom plus 2 per which allows for families with small children to sleep in the same room as parents. The existing ordinance has stabilized and decreased the number of VHRs operating in Douglas County by cracking down on the bad actors, as someone mentioned earlier. The operators that follow the law have a complaint rate of less than 0.5%. We ask for you to support the decision made by the Planning Commission and not to the county with these proposed changes. And on a personal note, I was probably one of the last people that was able to rent vacation home rentals in East Fork Township, and I was so sad to see them leave because when my parents were dying, there's 11 children in my family, and we all wanted to have a family holiday together before they passed away. And we rented the only 2 available in the whole freaking county, and we had an amazing time. We weren't there to party. We weren't there to be loud and obnoxious and disturb our neighbors. So the people that are there to be loud and obnoxious and disturb their neighbors are the ones that we should be cracking down on. Thank you for your time today.
Good morning, County Commissioners, and for the record, my name is Janet Murphy. I'm here today, I'm going to switch gears here. The GIDs had received a letter from the clerk treasurers, and I handed one out to you, and it has this, looks like this. You guys should have that. And it was about the statutes regarding that all of the trustees were required to get $10,000 surety bonds on them, which has never been done since the 31 years that I've been here. And I'm sure Commissioner Rice is aware of that. He served, of course, on 12 years on the GID board at Round Hill. Chairman Gardner, also TRE. As you know, that 90%, if not all of them, are in the insurance pool, which covers that surety bond. Also, another question is it just says surety bond. Do you know how many types of surety bonds there are? Many of them. The people in the statute that is to establish it is the county commissioner. So I'm bringing it to your attention because the clerk treasurer was requiring it. We have also sent her the information as well. And we just want to put this to rest. And that's why I'm here today, just to bring it to your attention that we are covered. And I gave you the information that supports that. If you have any questions, more than feel free to call any of the districts, because we've all, even the fire department, we were all required to do this, but we already have it in place. And as far as VHRs, you know how I feel about VHRs. I don't mind VHRs. I just don't want them in the residential zoned area. The legal term for residential is where you reside and live with your children and families and for a 6-month period. These aren't 6-month period. So I would look into that also. I don't even know if it's legal to only segregate to one area, to the township, and not the entire county. Because like I had said previously in Washoe, the DA in Washoe said that they told Incline they had to do it countywide. So, well, you know how I feel about that, but just to give you information, you want to call on me anytime. Thank you for your time.
My name is Lorraine Marlowe. My husband and I are longtime residents of Douglas County. We have lived full-time in our home in Kingsbury Estates in Upper Kingsbury since 1984, 39 years. This has been a single-family residential neighborhood for a long time. Our house was actually built in 1966. Please note, Tahoe Village is a separate plan area from Upper Kingsbury. We are in support of the VHR Advisory Board's recommendations for changes to the code. We are against the Planning Committee's recommendations, in particular, to increase the number of VHRs allowed in neighborhoods from 15 to 20%. While this increase may be considered fair to VHR owners, it is not fair to actual residents who live up in Tahoe and have to put up with the parties and noise. If one of the reasons for allowing more VHRs is increased revenue for the county, then a simple solution would be to open up the valley to VHRs. Another issue we have with increasing transient occupancies is emergency evacuations. We've been evacuated 3 times during our 39 years in our home. It's our opinion that residents would be more prepared for emergency evacuations than vacationers. VHR owners should be required to give their renters detailed instructions on what to do in case of evacuations. Another issue that you might want to address, especially in light of this winter's massive snowfall, is should there be a requirement that VHR owners or property managers keep an eye on their properties for snow load dangers and snow and ice covering gas meters and piping. There have been articles in local news about gas companies warning homeowners and residents to please keep gas meters clear from snow. Are the VHR owners required to do so? I want to thank the VHR Advisory Board for all their hard work in trying to come to an equitable solution for both VHR owners and the residents of Douglas County. Thank you.
My name is Debbie Affenberger, and I'm a 2-tier permit holder in Zephyr Cove. Our home was built 90 years ago, and for most of those 90 years, we've rented out to families during the months of July and August, most of those families being multi-generational. This year's renters, 5 out of 6, have been coming to our home for over 20 years. These families comprise of grandparents, parents, and their children. Right now, our upstairs bedroom has 2 full-size beds in it, giving us the occupancy of 8. Should our occupancy be reduced to 6, these families would no longer be able to rent up there. As for the daytime occupancy, the same thing. Their families, like our families, enjoy having people come up for beach time, maybe a barbecue after that. These are not party goers, these are families, and I hope they can make more memories. I hope the board recognizes that permit holders and guests that follow the rules are not the problem. Thank you for all your work.
Hi, my name is Deborah Oliveri, and I live in Granite Springs. I bought a home that I thought was in a zone neighborhood for single-family residential only to find out that there are 5 VHRs in my immediate proximity. The people that live there are under 30 people that live in my neighborhood, But when we have those 5 vacation rental full, suddenly our neighborhood gets another 50. Okay, those 50 people are not like my neighbors who come and go to work, doctors, dentists, kids going to school. They're people that came to have a good time, to make memories great. I say, make your memories. We have hotels here in our area. If we need larger hotels, if we need hotels that accommodate families, perhaps we need to build that type of hotel. But certainly not in a neighborhood where children are growing up, where children want to ride their bikes, play, be out in the streets, enjoy freedoms. Suddenly we don't know who's coming into our neighborhoods because these people that rent, we have no idea who they are, what they're doing. The only time you hear from us is if we have a complaint, perhaps, but when it's already at the point where I have to complain, it's past the point where I've enjoyed my freedoms of single home ownership and privacy. Thank you.
What was your name again?
Deborah Oliveri.
Good morning, everyone. My name is David Winter. I've been living here now 20 years, and I have entered the lottery, and as of 2 weeks ago, I just finally got our vacation home rental permit. We have a 5-bedroom home, and we got a 10-person occupancy limit with 4 parking spaces. One of the issues that I have with this new proposed regulations is your 100-foot rule. I can't pick up my home and move it 100 feet away from the neighborhood. When my home was built in 1976, there was no zoning requirements of 100 feet between 5-bedroom homes and other 5-bedroom homes, or whatever the thing is. You now turned my home into a 4-bedroom home without anything else. I think that's something that people aren't even thinking about in the residential areas. We're in Lower Kingsbury. The new regulation proposes a noise monitor on the Tier 3, which is what I would become, maybe, or maybe not. We have a band that practices every weekend, and we have a noise monitor out there. I think that's going to be setting off the noise monitor more than whatever guests that I haven't had any complaints about yet, nor have I had anything. Another issue I have regarding the proposed regulations is the subdivide into smaller units. Nobody knows what the market is going to bring. Our particular house is 2 stories. It has a separate living and kitchen area on each floor, sort of like a mother-in-law place. This particular regulation that's now being proposed is we can't rent out only part of it because of the market and say stay in the upper half. We have to, it's kind of like an all or nothing thing. And I think you shouldn't care if I have adequate parking, if I have the room, if I should be able to do it. That enables you to get your taxes. That gets me a little revenue, instead of just saying it has to be 10 persons. That also has to do with your advertising proposed change, where you're saying list the occupancy in the title. Titles are already limited in time of number of characters you can put in there. You aren't being very specific of what listing. Do you have to say occupancy 10, the number 10, total occupancy, whatever, using up my title, and then being vague and ambiguous about the saying what the occupancy is, when the regulations should just be say how much it is in the thing. I also want to conclude basically by saying that almost every listing is wrong. It's in Airbnb, and there's no enforcement. You're proposing new regulations, and yet there's still going to be no enforcement. There's no age requirement on Airbnb. Nobody puts in there the Airbnb requirements, and therefore, without all enforcement, all these new regulations really make no sense. So thank you for your time. If you have any questions, feel free to address me later.
Morning, Commissioners. Dan Ainsworth. I'd like to ask for a clarification on something. The topic of commercial activity has surfaced again in kind of a big way, some major postings. And I'd like you to clarify the difference between commercial activity and transient commercial activity. There are a number of homeowners associations that prohibit commercial activity but allow short-term rentals, which is defined in NRS as transient commercial. So I think the public deserves an explanation on that and clarification, and maybe the board does too, so we can kind of put that one to bed and work on the topics at hand. Thanks.
Good morning. My name's Phil Oliveri, and I'm a 7-year resident in State Line, Nevada, more specifically Granite Springs. I'm opposed to the VHR board's proposed increased VHR density, especially in single-family residential areas. Additionally, I do not understand how the county can continue to allow VHRs in neighborhoods with CC&Rs prohibiting commercial use of single-family residences. These VHRs are commercial businesses, collecting revenues, outsourcing maintenance management and oversight, advertising, and paying business taxes. My recommendations is 0 increase to VHR density in our single-family residential areas. Thank you.
Good morning. I'm Steve Kaplan, and my wife and I own the VHR at 650 Tina Court. And we've also been full-time residents of Douglas County, Upper Kingsbury, for over 11 years. And I'd like to start off by complimenting both code enforcement and the VHR Advisory Board for all of the work they've done, not only for today, but in dramatically improving the program overall and to helping ensure that VHR hosts act responsibly. In August of last year, the 6 closest residents surrounding our property, half of whom I didn't know, all sent emails directly to Douglas County detailing their experiences of our VHR. And here are some brief excerpts. 675 Tina Court, 2 doors over. We have never, not once, heard any music or other noise. 658 Tina Court, next door neighbors. Kay and I do not feel that the Kaplan's VHR has changed the neighborhood at all. They run the VHR very professionally. 670 Tina Court, 2 doors down. I found the renters to be very respectful of the neighborhood at all times. We have never heard any voices, music, or loud noises coming from 650 Tina Court. Similarly, we have never had an issue with parking or cars driving past. 651 Tina Court, 651 Linda Way, below the house and to the left. Our house, or to the right, our house rests northwest of Tahoe Blue, approximately 250 feet away. Our house is incredibly close to this property. Many of our windows face it. Since we do not have air conditioning, our windows are open during the summer months, and again, we've never, not once, heard a man-made noise. 208 Beverly, that's the one down and to the left. On no more than a handful of occasions, I have heard muffled voices coming from the property. These were all during the day and never after dark or late into the evening. 610 Beverly. Our residence is immediately below and in a direct line of sight of 650 Tina Court, approximately 397 feet away. On August 6th, the weather was clear and beautiful, and our doors and windows were open. I had been working in my garage and around the house that day and not heard a single sound from 650 Tina Court. Any allegation of excessive We appreciate the lengths to which Mr. Kaplan and his staff go to ensure they are being good neighbors to the community. This approach should serve as a model. The enthusiasm of all 6 neighbors for our operation is a reminder that while a small number of anti-VHR residents tend to make a whole lot of noise, the vast majority of residents fully support the VHR program. Thank you.
You have to excuse me, I poured coffee on myself. It happens. Nancy Gilbert. I know. I wanted to talk about the density issues. I believe last year when I attended the task force meetings and the Board of County Commissioners, there was concern about density in the Tahoe Township. And so there was a request to the task force to evaluate density. And then they asked Ernie Strelo to evaluate that. And he did a pretty comprehensive report. I don't know why we're moving away from that. If you look at it, he explained during the meeting all the reasons because of either narrow roads or hilly areas or not suitable because of evacuation issues. So I'd ask that the Board of County Commissioners evaluate and take seriously Ernie's work. It was pretty comprehensive and it was objective instead of a subjective 20% across the board. I wanted to parrot the issue of enforcement. I recognize that Ernie's doing a great job in terms of trying to get a handle on enforcement. But I think that if you have a vacation rental or a commercial activity in a neighborhood, warning letters are okay, but it's like if it's endless, I think that there needs to be a little bit more of a criteria on how enforcement is handled. I know that we've called the sheriff, or sheriffs have been called in our neighborhood for violations. I can tell you that they're not familiar with the VHR protocols. So they'll ask, why isn't your association handling this or whatever, but they're not familiar. Maybe some training to the Douglas County Sheriff's Department so that they understand more comprehensively what are the issues and how they can either write up reports or have knowledge of the situation. Thank you.
Good morning, commissioners and staff. Thank you very much for having public comment and your opening here. I know you're going to hear a lot of comments from many different people in the community. My name is Natalie Yanish. I'm a resident of Douglas County since 2002. You have heard me come up and speak about the vacation home rental issue before. I did serve on the task force for the entire term of the task force. And I can tell you we spent a lot of time and effort in trying to make suggestions to solve the problem, if it is a problem in our community. I want to make a couple of points. This is a residential use. It is not a commercial use. It should not matter if someone's living at a home for 1 day or 10 years. They should all be held to the same accountability as far as our nuisance laws and ordinance goes. So enforcement seems to be the key that solves a lot of these problems in communities. Unfortunately, this has become a contentious issue. I moved to Nevada for a reason. I did not want to be in a state that overregulated on every level. And it seems like this is an overregulation and an overreach to try to tell people that they cannot garner income from the property that they invested in, as long as that they're doing so in a responsible way and that all the residents are following, whether they're there for 1 day or 10 years, our ordinances and nuisance laws. On a second note, I wanted to say I am on the Kingsburn General Improvement District Board. I've been on the board since 2012, and I also wanted to bring up the fact that we are going to be having stormwater issues that are going to be coming with the spring melt, and I think that it would be good for KGID and Douglas County upon maintenance of roads and right-of-ways and whose responsibility it is. We do our best efforts as far as sweeping, and that our roads are actually one of the main contributors to the points that you get for your TMDL, which is the Tahoe maximum daily load of sediment that goes into the lake. So that's a credit to you that we actually provide. So I would like to open that discussion and dialogue, and I appreciate your time. Thank you.
Hello, my name is Tim Barabee. First of all, I'd like to say that these are minor changes to the ordinance. No one's being deprived of their income. The income will continue. So I live at Tahoe Beach Club, and I'm hoping that the changes that the VHR Advisory Board is suggesting will be supported 100%. Specifically, the most important changes are 15% maximum VHR permits for all neighborhoods, not just single-family neighborhoods, but also for multifamily neighborhoods, and elimination of the +2 occupancy. Specifically, I live at Building 2, and we have 7 VHRs out of 21 condominiums. Those 7 VHRs have 16 bedrooms. The people who own those VHRs, normally when they're there will be 17 people there. When those are rented out during the summer, those 7 VHRs can have 46 occupants, almost 3 times normal. Those 46 occupants exceed the rest of Building 2. So there are 14 other units in Building 2, and we have 32 people maximum. So in essence, what you're allowing is them to take over our building, building 2. And not even that, even worse, we have a pool. We have a small pool. Those people take over our pool. So we have no access to our pool. So that is one of the huge things that needs to be changed, the +2 especially, and also the 15%. And then lastly, 75% of these people do not live in Douglas County. This is absolutely a commercial activity. They don't put up with the traffic, noise, trash that we do. They're making boatloads of cash with their VHRs. I think that the VHRs generate roughly $3.4 million in total tax revenue to the county. The county has $22 million in total tax revenue, so the VHRs are about 15% of that. So it's not like we're going to be crushed if it changes from 15 to 20. And lastly, these people never suggest any solutions. All they do is complain about being overregulated. It's, you know, residents have rights too. Please do the right thing. Thank you.
My name is Linda Dangler. I would like you to look at the red line document item 20.62.010B7. The Planning Commission removed the all-important clarification, making it so that their recommendation removes the opportunity to clarify the intent code. Please put back in the code the red-lined code that the VHRAB put into it, which says of occupancy, the number of vehicles, and the nature of living in a neighborhood. A very simple clarification. I'm asking the board to approve of the removal of 20.622.030I10, which redlines out the previous code that allowed up to 50 people, which has been for the purpose of having large events in residential neighborhoods. I'm asking the board to remove the proposed grandfathering in of the up to 50 people for reservations already made for one more year, code 20.622.030G6B. Ernie Strela gave the wrong code number in your packet for this. In doing this, he denied the BOCC and the public accurate info to find the code. He put in 20.622.030H10, which doesn't exist. Try looking at 20.622.030G6B, the code in which they want to grandfather in the 50 for already booked reservations for one more year. This harms those of us in our neighborhoods irreparably, and you can end that harm. The VHR owner is not required to prove that the bookings already existed, so they can book more. The only person who has asked for the grandfathered in 50 at the VHR and BOCC meetings and in emails to Bonnie Harwood of Code Enforcement is Steve Kaplan. Steve Kaplan ran a commercial weddings and event business at 650 Tina Court for many years. When I turned this fact into the Code Enforcement, they did not file a single violation against him for running a commercial residential business. Now they have put this in the code so that he may continue to have the bookings that were made during the years he was advertising his commercial wedding business and collecting event fees for the bookings. All of the bookings he wants grandfathered in were taken while he was still running his illegal commercial business. For you to approve of this code for his benefit is for you to allow him to continue to run his commercial weddings and events business for another year. You may make a few more dollars doing this, but the ultimate price that Douglas County will pay is a few dollars made. If you approve of this, you are accomplices to the illegal activity at 650 Tina Court. I ask that you vote to remove 20.622.030 G6B to protect Douglas County.
My name is Lindsay Congdon, and I'm the house manager for the VHR at 650 Tina Court. I'd like to briefly address some of the inaccuracies submitted for this meeting's supplemental materials. I am not a contractor. I was hired as a full-time W-2 employee August 1st of 2021, and my role has never been to manage weddings. In fact, we do nothing to manage any of our guests' events. We are a VHR with a 3-night minimum stay that allows our guests, per our Tier 3 special use permit, to host their own events, including small weddings. The guests are responsible for booking vendors and planning their own events. I personally screen every guest to ensure they fully understand and agree with the requirement for only intimate weddings that maintain the tranquility of the neighborhood. I'm there to answer questions, provide recommendations, and explain the logistics of the home. We have 10 noise monitors and 4 cameras positioned for audio to ensure no excessive noise ever inconveniences our neighbors. We also provide guests with 2 mobile noise sensors so they can monitor their own noise levels. We even take the additional precaution of hiring a contractor during the warmer months to patrol the area surrounding the property just to ensure no noise somehow escapes across the canyon behind the nearly 2-acre gated property. I personally take every single guest on a mandatory walkthrough before their stay. They must sign a contract stating they understand the VHR ordinance requirements and that they will allow no parking on the street and no outdoor microphones or speakers. Our VHR helps support many local residents and businesses. All of our actual neighbors are complimentary of our efforts, and I'm proud of the way we are able to responsibly allow others to share in the beauty of Lake Tahoe. Thank you.
Good morning. My name is Jim Pardee. For the last 2 years, my wife and I lived at 675 Tina Court, which is 2 houses away from the Tahoe Blue. And my comments today are primarily with regard to that property. With respect to noise, one thing I would point out, without going into the detail, we are directly downwind from the prevailing southwest winds. So if there was noise, it would definitely be coming to us. And there hasn't been in our 2 years there. A second point is that our bedroom faces the lake and faces the Tahoe Blue. We have 2 sliding glass doors that we typically keep open during the evenings and overnight in the warmer months. And were there to be noise, it would certainly wake us up or keep us from going to sleep. And that has not happened. With respect to traffic, a neighbor has 2 beautiful Bernese mountain dogs. I often go down and walk with them up and down our street. Between that and little trips to the gym and the post office and the Safeway, I'm down there enough that I have a pretty good feel for what the traffic is down there. And during our 2 years, there has never been an issue with traffic, parking, speeders, trucks, all that sort of thing. In closing, I would say that the management of that property is outstanding in the sense that it makes it invisible to us neighbors. Invisible in the sense we don't see it, we don't hear it, we're not bothered by it, we're not annoyed by it. So those are my comments. If there's any questions, I'd be happy to try to answer them. Thank you.
Guys, put in 3 minutes to put it all together. Okay, Lauren Romaine. VHRs create both a positive and a negative impact for our neighborhoods. The best way to accentuate the positive.
Yes, Lorraine, may I interrupt you
Yes.
for just a second?
Yes.
And I think you should identify yourself as a member of the VHR Advisory Board.
I didn't want to take up my 3 minutes with that
No, but I'm
extraneous
gonna,
stuff, but.
so we're gonna start your 3 minutes over
Sure,
again, but
okay.
I think that's important for
All right.
the audience to know
Thank
that are you speaking on behalf of that board or as an individual?
So, okay, Lauren Romaine, I am a resident. I am a VHR advisory board representative. I am a VHR owner, and an HOA member. So I will put on multiple hats throughout this, and I don't know if I can do that, but okay, thank you. VHR creates both a positive and a negative impact to our neighborhoods. The best way to accentuate the positive is to minimize the negative. Unfortunately, profits create moneymakers that drown out the voices of balance and sustainability. Thankfully, our advisory board was made up of 4 Lake residents and 1 previous resident, and we are all understand firsthand the issues that need to be mitigated. My focus while on the board was to find the balance point between the rights of an owner to rent and the peaceful enjoyment of our homes. Our recommendations have a few overarching themes. The tiers recommendation is for clarity and fairness. Insurance recommendation is for protection of taxpayers from liability. But the most important recommendations are the quality of life recommendations. Those are the 15% daytime occupancy, elimination of the +2, the 100-foot rule. All of our neighborhoods have special conditions and features. Some have dangerous curves, others have narrow streets, others have gates, others have concerns over evacuations, parking, and the list goes on. The best way to address all of those issues is by adopting the quality of life recommendations as a whole.
As we know, the more people, the more vehicles, the more parking, the more noise, trash issues. The statement of trash, noise, and issues, or parking issues, are a watered-down list of the negative issues VHRs bring to our neighborhoods. By adopting the recommendations of the VHR Advisory Board, it will alleviate some of that pressure that these masses create when they inundate the neighborhoods. As a map shows in one of the supplemental packets, the VHR renters outnumbered full-time residents and seasonal residents by 25% in one sample neighborhood. They outnumbered full-time residents alone by 33% in the neighborhood with limited parking. That is not balance. It is difficult not to look through the lens, your own lens. I rent, I'm a good renter, therefore every renter is a good renter, and why do we need these recommendations? We need them because not all renters are us. The neighbors cannot control who rents, and there are unfortunately many VHR owners who put profit before the peaceful enjoyment of their neighbor. Let me talk about enforcement. We know that the complaints the county receives are only the tip of the iceberg. In many neighborhoods alone, 75% of the issues never get reported to the county. We need to improve our enforcement of those quality of life issues, but we must also realize that we will never be able to fix them all, and we therefore are leaving the residents to fend for themselves. We can help that situation by not allowing such large numbers. We want this program to I want this program to succeed, and the best way to do that is by adopting the recommendations. One, completely or do not want them in the valley. You are acknowledging that there is a negative side to VHRs, and we must be strong and implement an ordinance that provides a better balance for all of Tahoe Township residents. And one quick thing about 1031 exchanges. I do believe, and I believe it's the understanding of the board, that it does not stop people from selling a vacation and then long-term renting for a year, so it does not. Thank you.
Thank you. Additional public comment? You'll need to go to...
I'm Dorothy Dean. I wanted to know why it's expressly stated in the VHR ordinance that people that have voiced negativity about vacation rentals cannot serve on the Vacation Rental Advisory Board. That seems illegal somehow. Why is that? Yet you have 2 vacation rental owners on the board, and obviously they're going to be pro, and then nobody is allowed to be on the board, on this advisory board that might have an opposing view. I just wondered why. Oh, and I also wanted to say about the number of complaints. I'm from Texas. How can you tell someone's from Texas? They will tell you they are from Texas. And my dad used to say, for every rat you see, there's 100 in the walls. So I just want you to know that about complaints. If they got to the point of making that complaint, if it was even recorded, it sounds like, then there have been hundreds of instances before, and now they're finally fed up and they're making the complaint. But anyway, I would love an answer about why there can't be somebody that has voiced opposition to vacation rentals on the board.
We'll try to get that to you.
Hi there, Allie Giordano. I own a small local vacation rental property management company in Lake Tahoe, and I support all of these changes. I think they're positive for the community. And, you know, there's a balance there. There's a balance to be found, and I think that this is actually a pretty decent balance. There are things that I don't like about it, you know, selfishly, sure. I mean, I don't want to have to lose my sleeper sofa and my little 1-bedroom that I've had for 8 years, you know, but I get it, you know, and I'm, whatever makes it a balance. I mean, there's no reason to ban vacation rentals. We can all work together. We can give it time to actually see if these changes can work, you know. And as far as enforcement is concerned, I mean, we haven't really seen a lot of actual enforcement of these rules. I mean, I think that people should be licensed, especially for the upper tier levels, you know. I mean, put noise sensors in the house. They should have 24/7 monitoring, hire a team of people, you know. These bigger houses require actual systems and staff, and I agree with that, you know. So anyway, I don't really have much else to say. I just wanted to let you know that I know this is a really tough battle, and I'm just here for balance. Thank you.
Members of the board, staff, I am from Texas. We luckily didn't have rats in our walls. I am a member of the Planning Commission, but I'm here as an individual. I, as a couple of members who are present of the Planning Commission, attended the VHR Advisory Board meetings, and they did a spectacular job, in my opinion, of striking a balance between a commercial activity and residents. One of the things, and the only thing I really wish to offer you, which was the guidance that I used, and I can tell that I should compliment also Mr. Ritchie, JT, did a magnificent job of making this bulletproof in the event that there was going to be a lawsuit with respect to these changes, and commented on each one such that there was a rational basis for everything from advertising to occupancy, and did a very good job. But the guidance I offer you is present in 20.622.010, paragraph 7. And it states, quote, "It is the intent of the Lake Tahoe Vacation Home Rental Ordinance to make the transitory lodging activity permitted by this chapter resemble the existing residential unit uses made by resident owners and lessees." I think that's critical, and I think that the VHR Advisory Committee did an excellent job in implementing this guidance, which should guide us today. Thanks so much. I'm available for questions to the extent that you have any.
Thank you. Well, I know who you are.
Yes,
and
sir.
others know who you are. I need you to state your name for the record.
Oh, Paul Bruno, sorry, the Texan.
And you can't prove it by your shoes.
No, no indeed. I've been in Nevada long enough.
And no hat. Where's the 10-gallon?
No hat. I did leave my boots at home, but I possess several pair.
Thank you.
Thanks so much.
Hi, my name's Kelly Rogers. I came down to the meeting and wanted to listen to see what the different sides were for the whole VHR thing. I happen to have one, and I was hatched down here at Barton about a lifetime ago. So my situation, I don't know that I'm in it by myself, but to have a cabin in Tahoe, a family cabin that you don't stay at all the time, this is my only avenue. I can't rent the house out full-time because then we don't get access to it. We've been with VHR since its infancy, and it's enabled me to have the kids schedule time for it, you know, family, all that kind of stuff, get-togethers. But I just don't want that taken away, and I think you guys are governing it pretty well. We haven't had any complaints, and we've been with VHR for like 14 years. The neighbors are all good with it. I think it's just the way you're managing it is great, you know, so I'd like to see it keep going. Again, I don't think that I'm the only one in this situation. We're not using it to make, we're not cutting a fat hog off of this thing, we're just paying for it. So I appreciate your time. Thank you.
I have to do this. Maureen Casey for the record, speaking as an individual. I'm not from Texas, but my mother is. I attended several VHR meetings online, and the last one when they made their final decision, I read the VHR ordinance several times. I spent dozens of hours deliberating over it, and I have my few little quirks and issues with it, but overall, I defer to the wisdom of the Board of Commissioners and to the hours and hours and hours that the VHR board spent listening to public comment and their own deliberations. I have listened to staff and talked with Ernie Strelo and AJ about it. And my whole thing is empowering staff without making them dictators to enforce the code and to handle the bad apples, so to speak, who violate our ordinance and give the intent of Douglas County Code and Douglas County in general, a bad reputation when it comes to our vacation home rentals, and make it a less than honorable place to come visit and a less than wonderful place to live. And I wish you the best of luck in your deliberations. Thank you.
Mr. Chairman, I have a public comment which you've had in all the past, and I'll be very nice about it too. I won't say anything bad.
Commissioner Tarkanian, when we come back, as long as we don't have any other public comment from here, then we'll come back to you, okay? Just a little bit of patience, thank you. Is there any other public comment here? Okay, now Mr. Tarkanian.
Thank you, Mr. Chairman, since Jennifer had already told us that before. I just wanted to address two quick things. Mr. Ainsworth, you asked a very good question. There is no difference between transient commercial and commercial activity. It's just a subset of what commercial activity is. But the Supreme Court, Nevada Supreme Court has ruled that VHRs can be placed in, they are transient commercial activity, and they can be placed in residential neighborhoods unless the legal documents prohibit them or the county commission prohibits them. And that's where we're at. As I mentioned in my newsletter, which I send out before and after each county commission meeting, if anybody wants to get one, please contact me after this meeting, or you can go to my, you can get a hold of me in my email at the county email place. But as I mentioned in there, I tried to get VHRs banned from commercial activity, and it passed the first vote, and then it was changed by staff before the second vote. But right now, the way the law is, you can't have VHRs in transit commercial places. I mean, transit commercial places can be in residential neighborhoods. With respect to Dorothy, you're right. I mean, it's a good question. Anybody who is affected by VHRs positively or negatively would have an inherent bias on the board. We voted 2-2. We voted to have 2 permit holders and 3 non-permit holders on the board. And then we were erroneously provided information that a judge told us we couldn't, and we changed it. And now we had 3 permit holders, and one of them gave it up, but made it a little bit unbiased. It was biased the other way. But anybody who either owns a permit or lives next to a VHR is going to have a bias. You're absolutely right. It's naive to say otherwise. In fact, Ms. Graff, when she responded back to me with an email about VHRs at Glenbrook, she showed her concern wasn't about the fairness of the VHR. Her concern was one wealthy homeowner who used this as a second residence was trying to drive everybody else's VHRs out. So she was definitely biased, but she was on the board and still on the board.
Thank you. I was going to ask those questions of staff, Mr. Tarkanian. Mr. Haynes, as legal counsel for the VHR Advisory Board, or Mr. Ritchie, do you have anything to add in regards to the issue of the commercial activities and transient commercial activities?
This is AJ Hames from the Douglas County DA's office. There was a ruling by the court that residential activity includes VHR activity. In essence, if you're living in a house, whether it's for a few days or 20 years, that's still a residential use of property. And so that is accurate.
They actually called it transit commercial use.
Mr. Tarkanian, would you allow staff to answer the question, please?
Mr. Chairman, he did. And Mr. Chairman, I had a follow-up question.
Sorry, what was the follow-up question?
They didn't say it was a residential use. They said it was a transit commercial use that was allowable in residential neighborhoods. You're talking about the Oaks Point case that was handed out in September, correct? Something I guess the chairman doesn't know about.
Yes, in that court decision, the Supreme Court found that that if you're using the property in that manner, it's consistent with residential use.
Thank you.
Follow-up, unless it's banned by the Board of County Commissioners or outlawed by the legal documents specifically. And commercial use itself wasn't considered banning it. It had to say you were banning VHR use.
A.J. Hames, again for the record, ultimately the board has say over use. It's the board has final say in any kind of zoning regulation, all of which would dictate allowable uses within any given district. And so as far as regulating use, this board does that all the time. The VHR ordinance that we're discussing here today is just another opportunity for this board to state policy-wise what types of uses we want to allow in certain areas here in Douglas County.
Mr. Ritchie, anything else to add, or are we good with this?
Thank you, Chairman. Doug Ritchie with the Douglas County District Attorney's Office. As to the issue of transient commercial use, Commissioner Tarkanian is correct. And as A.J. Hames explained, one of the basic police powers of the Board of County Commissioners is to regulate land use. And so the board can determine what is a permitted commercial use is, including transient commercial use. I think sometimes people get confused when they refer to banned or permissive transient commercial use. They're referring to NRS 116.340, which deals with transient commercial use within certain planned communities, such as an HOA. Just for simplicity, if the Board of County Commissioners bans that use, then it can't occur anywhere. However, if the board allows VHRs, which it currently does, subject to certain regulations, notwithstanding that, planned communities, HOAs, can enter into regulations that prohibit otherwise permitted activities. The best example I can give of that is if the county banned pink houses in the county, that would ban pink houses everywhere. I'm not saying that's a good idea or if it'd be legal, but as an example, the county banned pink houses, you could not have pink houses. However, currently the county does not ban pink houses, but an HOA, because it's a private contractual relationship among members, they could, through their regulations, ban pink houses. And you could view that the same way with this commercial transient use. Notwithstanding the county allowing VHRs, a transient commercial use, subject to regulations, a group of homeowners through an HOA, through their rules and regulations, could ban that. And the issue is because it's a private relationship, each group of individuals, each planned community, each HOA can define for themselves what constitutes a transient commercial activity and whether it's banned or not. That's kind of a long answer to kind of help clarify that issue.
Thank you. I would also, I'm sorry, I didn't catch your name, but Dorothy Dings. Dean, as in James Dean. Okay, regardless, okay. I have hearing aids, and so, anyways, Dorothy, Miss Dorothy, can we address that question that she asked regarding the specifics regarding appointment to the board in regards to, okay, very good.
Thank you, Chairman. Doug Ritchie with the Douglas County District Attorney's Office. I can understand perhaps the confusion on that issue. This is found in 20.622.060A3. It states, no member may be appointed to the VHR Advisory Board who's expressed opposition to the VHR program or otherwise appears to have a bias that may improperly influence their impartiality as a member of the VHR Advisory Board. This came about because as the county was trying to create the composition of the VHR Advisory Board, create a neutral body, an unbiased body. There were certain individuals who had expressed an opposition to VHRs. They thought they should be banned, period. It was thought that it would be improper to have somebody who wants to, well, there's a feeling that somebody like that might sabotage the VHR program, that they would use their position as one member of a 5-member body to actually undermine the VHR Advisory Board. Therefore, if somebody expressed opposition to VHRs and said the county shouldn't have them, it was felt they should not be on the board because the Board of County Commissioners had implemented these regulations for VHRs. Now, obviously, the VHR Advisory Board, they can make recommendations regarding changes to the composition of the board or appropriate regulations. But that, and again, this came about as a part of discussions with the plaintiffs in the federal lawsuit, the Kaltoff litigation. And so both plaintiffs and plaintiff's attorney discussed their concerns with the county, and the county commissioners, after a lot of thought and consideration, revised the composition of the VHR Advisory Board and included that language.
I think that is completely, I mean, you're essentially.
Thank you, Ms. Dorothy. I'm sorry, but it's not for a time for exchange back and forth. But yeah, so anyways, okay. It's 11:07, and I indicated to the board that we are going to break for lunch today at noon. Okay, so but I sense we need a short break. Can we take 10 minutes and come back at 11:20? That's 13 minutes actually. So we'll come back at 11:20, but we will have a hard break at noon. Mr. Strelo, we'll have a hard break at noon. Okay, very good. Thank you. Okay, it's 11:20. I'd like to bring it back into session, please. If you would please take your seats, I would appreciate it. Where's Commissioner Hales? Is she available? Oh, there she is. Okay. And Mr. Ritchie? Okay. Okay. There was one other item that was brought up during that exchange, and that was in regards to the indication or implication that the wording in the ordinance when we first passed it back in April or May or June, I can't recall exactly when we passed that motion to approve this, but in regards to the changing of wording in regards to commercial, and I believe our Assistant County Manager, Jennifer Davidson, has some observations or information or insight into that. Could you please clarify that process? Thank you.
Thank you, Mr. Chairman, members of the Commission. Jennifer Davidson, Assistant County Manager. I appreciate the opportunity to clarify what occurred. At this point, I think we're probably a year and a half ago, possibly closer to 2 years. I'm losing track of just how long we've been talking about this matter. In multiple public meetings with the County Commission, we did spend quite a significant amount of time discussing this ordinance. A portion of that time was devoted on the public record to workshopping with the Commission line by line, I'm sure you remember just as well as I, regarding possible changes to the ordinance. At one point during those discussions, Commissioner Tarkanian had proposed a change to the language, which included a change to a reference, and I don't have that exact motion before me, but a reference to VHRs as a commercial activity. The recommendation by Commissioner Tarkanian did pass with a vote of the Commission at that time. In addition to a number of changes that staff were directed by the Commission to implement and to bring forward at a future date. Subsequent to that meeting, staff did meet with legal counsel to discuss the changes and to prepare a draft of the ordinance to bring back to the County Commission. In staff discussions with legal counsel, there was concern raised regarding references to VHRs as a commercial activity. Mostly because the concern by legal counsel, and Mr. Ritchie, feel free to jump in at any point because Mr. Taylor and Mr. Ritchie, were involved in these discussions. The concern by staff was that references to VHRs as a commercial activity may potentially undermine the ordinance, and here's why. Commercial activities in Douglas County, we have zoning regulations and land use regulations. And the state legislature in the statute had referred to it as a commercial transient use. And then also in a number of court cases, it was discussed as a commercial transient use. And so the concern by staff was that a reference to it as a commercial activity could potentially undermine our ordinance, our zoning and land use planning, and muddy the waters in terms of how we were handling it, which was we were permitting this and treating this as a special permitted type of use in our county. And so the recommendation was to change that language. At the time, staff reworked the language to make it acceptable in consultation with legal counsel, and we did bring that forward to a subsequent meeting of the County Commission. At that meeting, I read into the record what the original motion of Commissioner Tarkanian was, including what the board had voted on and passed. And I also read into the record what the recommendation of staff was. And I asked the board to take, if they agreed with the recommendation, to make a motion to make that change and remove the reference to commercial in that section. The board did go with staff's recommendation at that time and did pass that change. All of it was done on the public record, and fully disclosed by me. I did share those minutes with Commissioner Tarkanian. I know he expressed concerns about how that occurred, but it truly was a discussion by staff and a recommendation which we felt was in the best interest of a workable ordinance moving forward. I'm happy to answer any questions the commission may have.
Ms. Davison, the motion I made didn't refer to VHRs as commercial activity, did it? That's what you just stated, but that's not accurate, is it?
It had the word commercial in the motion.
Yeah, it did, but it didn't refer to VHRs as commercial activity. In fact, you sent me the copy right here. It says, the VHR, the statement by the owner confirming it is not deed restricted or governed by CC&Rs or bylaws that prohibit commercial activity. So I'm not calling VHRs commercial activity, even though they are. What I'm saying is that the deed, what I voted on, which the rest of the board voted on, was that if the legal documents, deed restrictions, CC&Rs, or bylaws, prohibit commercial activity, then that was a neighborhood that was inappropriate for VHRs. Now, that's a policy decision made by the board. That's not a legal decision made by staff outside of the board's direction. And I made the motion, it was adopted, and I wasn't told about this until 2 days beforehand. And in each one of those meetings that you have on Tuesday before the meeting on Thursday, staff and legal counsel gets to discuss with the county commissioners each of these items and the reasoning for these, and the other county commissioners aren't around. So another problem that I have with what occurred was you and staff and the legal counsels are able to get to people like Chairman Gardner, who's the one who made the change of his vote, and discuss the reasons for the change, but in the open meeting, we didn't get a chance to do so once the motion was already made. So, you know, if this was gonna happen, I think the first thing that should have happened was you and legal counsel should have sat down with the commissioner who made the motion, explain what the reasoning was, and then discuss the best way to approach it. Not blindside the commissioner 2 days before and meet with other county commissioners and express your reasons why. And furthermore, with the public here today, I think it's important they don't leave here with understanding that what you said, that I call these VHRs commercial activity, and that's why it would affect the bylaw, affect the land use plans. I just stated that if legal documents, bylaws, CC&Rs, and whatever else it was, if they banned commercial activity, then VHRs were not appropriate in that neighborhood. That was a basic motion I made, and it was approved. And there was no reason to change it.
So, since I'm being brought into this, I will respond to that as well. And on the initial go-around, we had not, by the way, through this process, we were in the negotiations and in the discussions of a final ordinance, and we were looking at different clauses, so we were not passing a final ordinance at that time. When I saw the staff come forward with some, what I thought were bona fide reasonings behind not having that word commercial in that ordinance, that's when I did change my views on that, and I did change my vote, Mr. Tarkanian, and there's no question about that. It's on the record, and I'll own up to that, okay? But the word commercial, in my mind, is just too broad, and we do not prohibit homeowner associations from outlawing or banning vacation home rentals in their neighborhoods. And so it seemed to me that the neighborhood you were talking about, in regards to the commercial activity, it would be much easier for them, rather than painting this broad stroke of commercial activity. I felt it was best that HOA address that in their CC&Rs individually. They've had 2 years now to do so and have failed to do so as a neighborhood. So I'm not sure that HOA necessarily wants to ban vacation home rentals in their neighborhood. But anyways, that's the other side of the coin. And, you know, and so I appreciate when staff sees something before we have finalized an ordinance, and rather than having to come back and open it up in another meeting, we can change those and massage those as we go through this. That's basically going to be the same process that we're going to follow today. Am I right, Mr. Strelo? You're going to offer some suggestions of the VHR board to us that went to the Planning Commission, which is the proper process, and now is before us. As you discuss each of those items, we will have an opportunity as commissioners to weigh in on each individual item as we see it and say we agree with that or we disagree with that. And it takes 3 members to agree and 3 members to disagree that will either strike it or approve it. So as we go through that, we'll have that process. Once that is in, once we get through that process, then the vacation home board and community development will know exactly what ordinance we want back before us in presentation form at a later meeting. I don't know if it's going to happen in 2 weeks because there's a lot to go through, but then eventually it'll come back to us as a presentation item, and then it'll come forward as an ordinance. Now, when we get back to the process of it coming before us as an ordinance, guess what? We have the opportunity then to also amend that ordinance if we don't like it, and it'll have to go through that process one more time. Is that the correct procedure, Mr. Hames?
AJ Hames from the DA's office for the record. Yes, that is the procedure. The purpose of today's meeting is to try to gather insight from the board as to what should go into an ordinance. And so I think the context of prior meetings is helpful in sort of establishing the history of how we got here today. But I do want to also emphasize that the purpose of today is to discuss revisions. And so to the extent anyone feels strongly about any of the recommendations of the advisory board, any of the recommendations of the planning commission, or if anyone has any other ideas that they want to propose, whether they are to disband the program entirely or to make drastic changes to what we currently have, what the advisory board's proposing, or whether you just want to make small changes, that is the purpose of today. The county will then, myself working with staff, will attempt to encapsulate all of that into an ordinance. And to the extent that there are things that seem inconsistent with what you thought was happening at today's meeting, at the next meeting, that would be an opportunity to get clarification or to fix things if you see any kind of problems. And so I think the past is helpful to understand, but the purpose of today's meeting really is to try to, with everything we've learned, both Mr. Strelo and myself, we've now been working in this capacity closely with VHRs for a year, roughly. The advisory board's been working on these issues for over a year. With all of that knowledge, trying to put that into an ordinance today that can effectively carry out the purposes set forth in the ordinance. And so it's possible that at our next meeting it won't be perfect. There might be things that you perceive in that ordinance that will be proposed that are not exactly what you had in mind, and the next meeting would be the opportunity to address those. But during this meeting, we hope to get as much insight as we can from the board so that we can draft something that is appropriate.
Mr. Chairman, one clarification. First of all, my motion didn't deal with one neighborhood. And that's been a lie that has been perpetrated through people in the community that want to weaken my positions against VHRs. In fact, one of the first meetings I had with Commissioner Hiles is she heard that I was pushing this ban on VHRs just for Glenbrook because I had a large donor who had given me money. I said that's an absolute lie. I don't have any donors that have given me large monies from Glenbrook. And I said, here, I'll send you a copy of every one of my, they're called income and expense reports. None of them have given me large sums of money. While the person who runs the property management group there is very close and did the property management for one of the advisory board members, Ms. Graff, and is very close with Commissioner Rice. There's much more bias there than trying to lie about me taking a large campaign contribution. When I asked Commissioner Harrelson, who's told me, Danny, don't bring these issues up in public, let's handle it behind the scenes. Well, I asked, well, who's saying these things? And she declined to tell me who was saying them, so I can't handle it behind the scenes, so I got to disclose them publicly now to you and waste time on this. Finally, you're wrong, Mr. Chairman, when you say the HOA in Glenbrook did not ban VHRs. They did ban VHRs, so you're wrong, they did. To anybody outside the HOA, so they are not, VHRs are not available to anybody outside the HOA in Glenbrook. Finally, Mr., I forget your last, Hames? It's okay, I knew AJ. So I'm gonna ask one simple question. If the Board of County Commissioners votes for a certain change today, does you as a legal counsel have a right to change the material effect of that vote?
I don't think that, I don't know, as far as authority, the purpose of when we
You
tried
can cut
to
it short.
draft,
You can cut it short. You know that you don't have the legal authority to change, to materially change a vote by the Board of County Commissioners.
well, you're getting into material. There are
Material
changes.
is a legal term that you're aware
Yeah.
of, so that's why I didn't just say any change. I said a material
change.
change, because you know what a material means.
The changes that are made between now and a subsequent meeting would be based on, sometimes some of the motions that are made are not particularly clear. And so they're,
That's why we use the word material change. Can
Sure.
you, as legal counsel, materially change a motion approved by the Board of County Commissioners?
not change the motion, no.
I have a question for you. I'm going to just say it simply. You know what this is?
Yes.
This is the summary. If I were to say the tier structure as written by the advisory board and the planning commission rejected, can you change that?
This is AJ Hames for the record. If you were to vote today that you dislike the changes to the tier structure and you wanted to keep the 3 tiers, you could do that, and we would bring back an ordinance that had the original 3 tiers.
Without lawyer talk. Current, the HR advisory board, planning commission. I like what we got now. Period.
So anyways, try to help you out here, Mr. Hames, is that what we're going to do is go through the proposed changes. We do not have to accept any of the changes whatsoever.
Correct.
And we can accept them carte blanche. We can go the whole thing. Or we can piecemeal it and choose and cherry pick what we want to approve. However, it's still, what we're looking for is a consensus of the board in that process, okay? So if 2 members don't like that particular change, but 3 do, then the recommendation going to you will be to go ahead and go forward with that. Or if there's 3 people who oppose a particular proposal, then you probably won't bring that back to us when you bring that ordinance to us. Is that?
Correct. AJ Hames again for the record. What we're trying to accomplish today, just from a staff perspective, is to discern where there is a consensus, and then we will put that into an ordinance. And so if this board hates the new tier structure that's been proposed by the advisory board, then just let us know.
So 3-2 against item number 1 in this list says don't bother, correct?
3, I didn't understand the question.
3-2 against.
Yes, if 3 of you hate the new tiers, we'll take it out of the ordinance.
Very well.
Thank you, Mr. Davidson. I appreciate that clarification. So as we go through this, I think you have, Mr. Trailer, if I'm not mistaken, some key points. And if we don't like those, then we just need to express that to you. And if we like those, then let's move on to the next one, right? Is everybody good with that? Is there, I want to make sure all 5 of us understand exactly what we're trying to do today. Okay, so I did indicate we're going to take a hard break at noon, so basically you have 20 minutes until we take that hard break, okay? And I just wanted to make sure that we got some nourishment here as a board, because this may take a while, right? So, Mr. Strelo, you're on. Well, no, I need to, wait a minute. I need to move back here, okay? We are done with public comment. We're going to go to the approval of the agenda for possible action, approval of the proposed agenda. I'll entertain a motion to approve the proposed agenda.
Mr. Chairman, I move that we approve the proposed agenda as presented.
Second.
Okay, motion by Commissioner Rice, seconded by Commissioner Noasad to approve the proposed agenda as presented. Sensing no further discussion, we only have one item. All those in favor signify by saying aye.
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 Okay, motion passes 5-0. Administrative agenda. Number 1, and the only one, for possible action, discussion on possible changes to Chapter 20.622 of the Douglas County Code relative to vacation home rentals in the Lake Tahoe Township, including consideration of recommendations made by the Vacation Home Rental VHR Advisory Board and the Douglas County Planning Commission. Before we go into that, I just wanted to go on the record as saying you've been, as Mr. Hames has indicated, have been beating this up for almost a year now, not quite maybe, and so I want to make sure that we acknowledge and appreciate the tremendous efforts, and I know that Mr. Strelo has been with us how long as the program manager? 10 months, okay, not even a year. So we welcome our Community Development Director, Tom Dallaire. Mr. Ernie Strelo is the VHR Program Manager. Mr. Hames, who is the VHR Attorney and the Planning Commission Attorney as well? No? Sometimes. And I did want to acknowledge the two members, I believe we have two members of the VHR Advisory Board here today. Ms. Hempler, Mickey Hempler, who is the chair, and Ms. Lauren Romaine, who is you remain as vice chair, right? So we appreciate your attendance as well. We may need to call on you from time to time as we go through this to get some feeling for how you arrived at some of your decisions and how you looked at other possible changes but didn't do that. So anyways, thank you very much, and we look forward to your presentation today.
Good morning, Mr. Chairman, commissioners, and members of the public. Ernie Strelo, VHR Program Manager and Head of Code Enforcement for the record. I had 18 minutes before I had to say good afternoon on here, so thank God we got that in correctly. Just want to remind that I'm a doctor of education. I'm not a lawyer, so if you have any legal questions, Mr. Hames is exactly the right guy to talk to. Housekeeping items first. The info in the packet includes number one, a staff report on page 6. Presentation is on page 14, and you'll see my little numbers up on the slide. You'll see 2 number 14s and then 2 number 15s. You'll go, what's going on with Ernie? Well, in the packet, there are 2 per page. So I referenced the packet numbers in there. The current code is on page 37. The red line proposals on page 53. A clean version of the previous red line is on page 77. The Planning Commission minutes pertaining to the 4-hour VHR discussion is on page 97. This is the March 20th meeting. And lastly, proposed VHR code revisions are on page 152, which I also reformatted into the PowerPoint. So it's just a word version of the same thing. So first, before I begin, as mentioned, I'm on my 10th month of this and have tried my best to meet people from all sides of the issue, and I appreciate you, the commissioners. More importantly, I would like to thank the tenaciousness of the VHR Advisory Board. Despite many differences of opinion, they spent the better part of 10 months, at least as long as I've been here, reviewing the code. And secondly, I'd like to thank the public input that came to the meetings to contribute, sometimes passionately, on what they want to see. Lastly, I'd like to share my appreciations of the dedication of my staff in both code enforcement and administration of the program. They hear everything we talk about here, and so it's both good and not so good, and I thank them for their patience and sticking with me on this. Item 1 appears on your agenda today to allow members of the County Board of Commissioners to provide direction on the proposed code changes for the VHR program, including the work the Advisory Board has completed and the Planning Commission has weighed in on. As a reminder, the Vacation Home Rental Advisory Board spent greater than 60 hours discussing and deliberating changes to code with thoughtful feedback of greater than 25 hours of public comment. In addition, the Planning Commission also weighed in and with additional public comment. What we are hoping to hear from you today is feedback and direction, and I underline that, direction, to assist me in our efforts to date to include anything you still think needs to be addressed or that should be a priority to include in the creation of an updated code. It is our intent to update the regulations and continue the good work of the Board of County Commissioners and the VHR Advisory Board that have done to make this a workable program for county residents. My hope is a first reading in early May. So, as we begin, on slide 14, we'll do a quick overview of the VHR program and then move into the review of the proposed changes brought to you by the VHR Advisory Board and then the follow-up review of the Planning Commission. So you'll see the current VHR Advisory Board, and then in the right column will be the Planning Commission input, if any. And then we'll stop for any questions before moving into the proposed changes. So if you are okay with this, I will move through the 10 slides of the proposed changes and then bring it back to you for questions and direction. So it's basically 2 parts.
Mr. Strela, I had one question on your timeline here, slide 14. Is that the next slide to this? You list the time there. Okay, thank you. So you're going to get direction setting and the public input that you've already had, and we'll have at the end of this review of this. And you're indicating that that based on our decisions today or direction today that we provide to you, it still may have to go back to the Planning Commission for additional review?
It's if applicable. So if we have, what I was told is that if we have a significant amount of changes that weren't in the previous presentation to the Planning Commission, then I have to go back to the Planning Commission.
But no requirement to go back to the VHR Advisory Board?
No.
Okay. I just wanted to make sure that's clear, because I had that question in my mind, and I would imagine members of the public would also.
Yeah.
Okay. So that's why it would perhaps delay. And so no matter what we do today, you're also indicating that we may, we're not looking for a presentation only item until May 2nd.
That's my plan.
Okay. I want to make sure we're all on the same page in regards to the timing on this process. Okay. And then we would, during that presentation, we won't be making any changes. That'll be a presentation only. So if it comes back to us then on June 6th and we recognize issues of that and want to make changes at that time, then we have to start the whole process over again, right? So
that's correct.
Not necessarily back to the Vacation Home Advisory Board, but at least to the Planning Commission and us again. So, okay, for a first reading again, right? So anyways, very important that we understand this process. I don't want to delay this that long. I hope we can get through this. So you may go, please.
Mr. Chairman, before you go on.
Mr. Noasat?
With regard to going back to the Planning Commission, if we vote one of these sections out, period, I would assume that all you're going to do is go back and delete that verbiage. Is that correct?
Sorry, AJ Hames from the DA's office for the record. You wouldn't necessarily have to go back to the Planning Commission unless you wanted guidance from the Planning Commission. So the Planning Commission has had their opportunity to discuss changes to Chapter 622, and those are included in the form of the minutes, which are in your packet, and the comments that have been incorporated into the presentation. So if you wanted more guidance from the Planning Commission, that's where you could send it back there. But if you're making changes today, those wouldn't necessarily have to go back to the Planning Commission first.
You say they would have to?
No, they would not.
They wouldn't. Okay, so if we eliminate the tier structure recommendations here, the only thing required would be to then go back and readjust the red line, correct?
Correct.
Thank you.
Mr. Strelo.
Ernie Strelo for the record. I don't know if I'm going to be done by noon, just so you know, but okay, so I'll give an update on the overview of the program itself before I get into some of the changes. Some of this you saw last October. This shows the 30,000 foot level view represented here as a heat map of where the VHRs are clustered in the Tahoe Township. You can see the southern portion towards State Line and Heavenly appear more populated than the northern portion of the county. The Kingsbury GID area represents approximately 70% of the overall permits. It's from Beach Club up Kingsbury on both sides, up to the top. On this slide, shows the density. It's a little bit more detail with an accompanying detail map on the southern portion of the county, which again shows where the VHRs are populated. The cutout to the right is the box of the left, magnified for detail. This is the exact slide I had last October. I think this is the distance slide. So this slide intends to show the TRPA overlay map of recreation, resort recreation, and tourist areas included in our GIS mapping. You will note that most VHR compilations appear to be 4 miles or less from the tourist and recreational centers. This slide is, like I said, similar to what we presented previously. I'm going to, on this one here, this I thought would be interesting for you to know. So we have about 525 active tier 2s and 3s. What I think what we presented last October was we had 47% overall rentals were Nevada-based owners. It's now 31%. 25% or approximately 25% are Douglas County though. So that didn't change that much. And it also, the data also indicates the trending of legal VHRs over time. This is the total of all the tiers. We tend to hover around 525. It was dropping and then we released a wait list, so it's hasn't really been changing a lot in the last few months. The last few months have indicated some stabilization of rental property counts, which is most likely attributed to the release of the wait list. This slide here is similar. So this kind of shows all the neighborhoods. And so if you look at the dark blue, that's the sum of the number of VHR units permitted that actually have permits in a neighborhood. It's a stack bar. So the light blue is the sum of the number of units remaining for those neighborhoods. So this will kind of give you a representation of where the density by neighborhood is, and there's about 39 neighborhoods.
Mr. Strelo, I had a question. Is it dark blue, it says some of VHR units permitted. That means the ones that are actively being rented. And then the light blue is the ones that are still available that's over and above the blue.
That's correct. And then the stack bar is the total of the two for that neighborhood.
So in that regard, does this chart reflect the proposed new? It does not.
No.
It's
No.
the current.
Correct. It's
Okay.
the current, to give you an overview of what the current state is of the program. And then this is a little bit of a breakdown of what you just saw of the tier 2. So as you know, we have tier 1s, tier 2s, and tier 3s. Tier 2s are predominantly all, they're 95% of the permits that are outstanding right now. And of the ones that are outstanding, this kind of gives an idea of what the current occupancy is that is outstanding. So it's kind of like a bell curve, sloppy bell curve maybe, but we have 4, and then the 6 to 8 and 10s are where the permitting predominantly is right now, as far as occupancy.
A quick question, sir. Got tier 2 occupancy, paren Y equals 497, close paren.
Yeah, I didn't change it. It's 497 of the permits are out of 525.
Thank you.
This one here, I'm going to
There we go. Tom Dallaire, Community Development Director for the record. Thank you, Ernie. So we presented this in October as well. We did have a Title 5 in our county code, and that section was created in 2005. It was updated in 2012. We had one amendment that has been done, and then in 2017, the board, this body, directed staff, and we're trying to consider ways to better regulate the VHRs. And this is because of the new technology that had come out. We've got a platform for rentals to happen, and the enforcement needed to be relocated, or enforcement needed to happen. And in Title V, with the code in that section, code enforcement couldn't actually enforce Title V. So The code enforcement is specifically for Title 20, and so it was relocated. Title 5 was relocated into Title 20 on August 16th, 2018. So that's when really the enforcement of this ordinance started. And at that time, the board directed staff to create a task force, which Jennifer Davidson, our assistant county manager, had basically ran that task force and had held many meetings. They came up with some modifications to the code at that time and made some recommendations for our county manager Patrick Cates to consider. You guys then took his recommendation in for consideration there in 2021, and then a lawsuit promptly happened, and we made 3 more revisions to this code through the end there in 2022. The current code is the Ordinance 2022-1599, which we are modifying, and you'll see has been modified in the red lines in the packet today, extensively discussed by the VHR board and Ernie over the past 10 months for Ernie and 2 months before he showed up for me. And I really want to appreciate, I really want to let that board know, the VHR board know that I appreciate all their effort and time and discussion and thoughtfulness in this process. I know it wasn't an easy task, and 18 pages of code has been discussed at length and just through and deal with this, and I appreciate you guys and your patience dealing with it again today. So so we are here today since that last revision and the settlement of the lawsuit. Meet on this regularly. They held special meetings throughout the last 9-10 months. They met twice a month, one for actual business and the other one to deal with the code updates. And Ernie and staff did a great job at making that happen. And I want to just express my appreciation to them for that effort. And then, and so what you have before you today is the recommendations from the Vacation Home Rental Advisory Board, and that then went to the Planning Commission last month for discussions, and Ernie will present to you the outcome of that in the following slides.
Okay, so I'm just gonna interrupt you now because this is where we are, and that's good. Now, as we're gonna take a break for lunch then, okay? And then we're gonna come back.
Chairman, he has 3 pages before he gets to the substance. I think you could probably finish those at a couple
What's that, Commissioner
seconds.
Tarkanian?
He only has 3 pages before he gets to the substance. He's just going to give you 3 more graphs. I think, well, you can do what you want, but I think that would be more appropriate.
I can talk fast.
That's a good observation, Mr. Tarkanian. I did want to mention, believe it or not, folks, it was Commissioner Tarkanian and I that worked heavily on that settlement agreement that was finally approved in April of 2022, believe it or not, okay? Just an acknowledgement. So we'll go through the next 3 slides and then we'll go to lunch, okay?
Okay, this is just a few slides just to kind of show you where we're at on some of the legal and illegal rentals. What I thought I would share is what has transpired on both legal permits and illegal renting, as well as our efforts to remove the bad actors, while also informing on legal rental permit expiration trending. This slide indicates the quantity of bad actors that we have found, find, and subsequently shut down. These properties are monitored daily to ensure that they are no longer being rented for VHRs without a permit. So this is kind of a step chart. So it tells you by month about how many we caught and we did something about, and then the total is over the last, since last June, is about 17 on the illegal ones. On the legal ones, this is a little bit of a mixed bag. It's so we weren't really tracking why certain people were giving up permits until very recently. So I have a pie chart after this, but this is we've lost about 85% permits that were legal over the since last April, most of which have occurred over the last, 8 or 9 months. And on the next slide, I tried to give a reason for some of it. But basically, the biggest problem, or not problem for me, but problem for the homeowner or whoever had the permit, is they were having problems meeting the permit deadlines. We have a 60-day grace period in the current code. In the new code will eliminate the grace period. But part of it, some of the feedback that we got on the gray area, the big part of the pie chart, is the difficulty of applying, which could be the software or the amount of documents that they have to upload. So that's some of the feedback that we've gotten, but I don't have real good data to, say for sure if that's entirely the whole reason why those happen. And then there's some others where we had a couple property management companies that this didn't apply on behalf of the owners of the VHRs to apply for permits, and so they lost the permits because it went 6 months. So we pulled them. So, and then that's all I have.
Thank you. The one observation I'd like to make, when we had, as we've gone through this whole process over the last 2 years, we have heard from the residents, our constituents. The biggest issue we had with this program was enforcement. We must enact enforcement. And if we didn't do that, then there was no sense in having really a program. So I appreciate what you have brought to the program in regards to making sure that we are enacting enforcement, because that is the key element of this ordinance. Without that, I don't know that it would be tolerable, I guess is what I'm going to say. Commissioner Nosad, you had a comment?
Yes, as a add-on to what you said about enforcement, part of that is going to have to be what do the enforcers have in the way of power? Right now, they're afraid to walk up to a door. Some of them are.
Ernie Strayfield for the record, I like to answer that. VHRs are a little different than regular non-VHR violations. And so we do lean on the Douglas County Sheriff on noise complaints and parking complaints. They do an excellent job of addressing that situation. They write police reports up and they send us a copy of the police report that goes into our code enforcement file, and we deal with it. So we either fine them, we revoke their permit, or whatever. But we work very closely with the sheriff on the VHR program. And so I would say that while the VHR, the code enforcement person doesn't have, they're not peace officers, they're code people. They can drive by from the street, and that's about it. We do lean on the sheriff, and they do a great job at supporting us on that.
Thank you. And this is a great place to stop then, as we can come back and go into the proposed revisions. I would like to make a public announcement that parking stickers, people have asked about parking stickers. So the parking stickers are good for 1 day only, and they're at the back of the room at the back table. So with that, we'll take a break for lunch and come back at, it's 12:04 now. We're going to resume at 1:15. That gives us a little bit more time, right? So 1:15 we'll resume. Thank you.
Okay, it is 1:15, actually 1:16. I think Commissioner Noasad is on the way, so if you don't mind, we'll wait a couple more minutes for him to. Noasad's here. Commissioner Rice. Commissioner Rice is on his way. So if you don't mind, we'll wait a couple more minutes for him to get here. So I did want to make one announcement. We're not going to take a hard break for dinner. Hopefully we're not going to need a dinner before we can get this done. So, and staff is looking at me like, you know, clerks are looking at me like, yay. Okay. So anyways, call the meeting back to order, and at this time, Mr. Strelo, you may continue your presentation. Now we're going to get into the meat of the matter, are we not? Okay.
Yes, sir. Ernie Strelo for the record. I would have ate my whole salad if I knew I was going to be here through dinner, too. All right. Slide 20 through 26, we'll go through the Vacation Home Rental Advisory Board of proposals, along with the PC Planning Commission proposals. First off, the sentence in number 7, which was brought up a couple times today, of the introduction to the code was referenced repeatedly throughout the code review process. While the Vacation Home Rental Advisory Board and Planning Commission meetings met, I thought it was appropriate to reference it once again for the record as we start the process. Okay, so I put together 19 different subject slides. However, on the right side here, I was going to focus on the red because those were the ones that we really we felt were the best ones to review first. If you would like to review any of them out, you know, beyond that, I'm happy to go through that with you. So the first one, right off the bat, is.
So I'm sorry, but as we go through each of these, I think it would be wise for the commissioners to weigh in and how they feel about that item individually, trying to build some consensus, and then we can move on to the next one, if that's okay with the rest of the commissioners. Commissioner Hales, you had a question?
Not a question, but it's probably a good time to interject this. As I've really tried to think deeply about this, what I keep finding myself coming back to is your chart, Mr. Strela, that you made that shows, suggests that one approach would be to do different percentages by neighborhood. And to me, that is really tied into fact. And it recognizes the serious difficulties of VHRs in certain neighborhoods by giving them a lower percentage, suggesting that one approach would be to do that. And it seems to me that if that the advisory board didn't pick up and run with the chart, mostly because they felt that it would create a perception of unfairness between one neighborhood and another. And that may be important consideration for them, but it's not so much for me. And if this board were to adopt such an approach, then some of the individual changes would have, we would have a different look at them if we were to do that. So it's fine with me if you want to go through this and we can make our comments as we go through, but I wouldn't rule out the possibility that we have a different approach. I'm very open-minded here, and I've done a lot of thinking, and I still have more to, I want to hear what you all think about this, and I'm open, but I wouldn't rule out an approach that is, that utilizes a neighborhood by neighborhood approach.
Sure.
I concur with Ms. Hales.
So is this in regards to the density area? I would assume, right? So if I'm not mistaken, what your proposal is, Mr. Strelo, is to go down through this list on the red, and so density is number 4 on the list. Are you suggesting we tackle density first, and then that might affect the other processes?
Well, being the newbie, I'm probably going to just make all kinds of mistakes here, but the way I see it is, if we adopt that type of approach, it reduces density so much that maybe some of the other issues may not be as pressing. So I'm not sure it's isolated to, I guess maybe density is a broader term than occupancy. So, or I just don't know. I think that type of approach you would have to rethink everything else you have done, because it would be a very different approach.
I don't have any dog in the fight here. It doesn't make any difference to me how we go through this process. I have indicated in previous meetings that blanket densities trouble me because of just the nature of the neighborhoods themselves. So if we want to tackle, for instance, and we have what, it's at 38 identified neighborhoods, and 39 neighborhoods, okay. I don't know that, how we tackle that is, I don't know if we want to look at in the manner in which Mr. Strelo has laid out, but if you want to tackle density first, I'm certainly open to that. It doesn't make, like I said, it doesn't make any difference to me how we tackle this. It's just, these are the areas that Mr. Strelo has identified that are probably the key areas of the new proposed ordinance. And so,
I'm fine going through, but I just wanted to make the caveat that this may, what we go through, my comments in some places may change if we were to do something different, quite a different approach.
Okay. Mr. Nosad, you had some?
Yes, I do. I stand for taking these things in sequence as outlined on the red. Granted, you may hear something in one of the previous ones that will make you change your mind on successive ones. So I suggest that we go down through this in order so as to not get confused as to where we are.
And then I would suggest, there's no reason why when we go down through this, we couldn't go back, we couldn't revert back to something else and say, now that particular item may not make sense to me, and so I'd like to go back and review that again. So you want to proceed through this list the way Mr. Strelo has laid out, Mr. Nosad?
Yes, I do, and I'm now going to ask the question, are we going to vote on each of these as we go through, or are we going to vote on them? Very interestingly, if we go through all of them, and there's all different approaches, so I would suggest that we take these one at a time, and if you vote yes on this, and then later on decide you vote no, then we would have to make a motion to revisit the issue.
So we're not voting, I agree with you today that we will take advisory votes as we go through this. It won't be a hard vote. We can come back and revisit each of these areas after we all express our feelings on the individual items. Yes, we're looking for a consensus, but that doesn't mean that that consensus may change as we go through this. And this is just giving Mr. Strelo, Mr. Hames, Tom Delaire an indication of where the majority of us fall on this after that occurs, and let's beat it up as much as we possibly need to beat it up so that we can try to get it right, and then it'll come back to us in the form of a presentation and an ordinance that we still may need to change when that real ordinance comes before us as well. But we all need to feel comfortable about where we are on this. So I would concur. I'd like to go through the tiers and then the occupancy as Mr. Strelo has laid out. But Mr. Rice, how do you feel about that?
I concur.
The other one.
I don't want to get lost in the weeds, and if we start bouncing from one area to another area, we're going to forget where in the Sam heck we are. So I would suggest going down the list, starting with tier structure, and work our way down one at a time.
Okay. You good with that, Ms. Hales?
Yes, I am.
Okay.
But I think all of you have had a chance maybe to share with the board and with the public your approach or your general feeling. And I would like to do that, because before we start talking about specific recommendations of the VHR board, I would like to explain how I approach this and what things are important to me. Okay.
Yeah,
So-
and I know you're new to this. The four of us have beat this up for 2 solid years, and we're looking forward to trying to get the nail in the coffin, so to speak. Maybe
Well,
that's not the right analogy, but
I appreciate your indulgence, so I can share these things, being as I'm new. I wanted to say that I take this responsibility seriously, and I feel that it's kind of a heavy burden because there's a lot riding on it, and I want you to know that. I feel that way, and I have read every email, I have read every written public comment, I have met with numerous people, I have taken phone calls, and all of that, I've listened to you today, all of that input is valuable to me. It would be a simple question if we could have enforcement. Perfect enforcement. It would be a simple question. So right now we have, of course, the interests of residents who want to have peaceful enjoyment of their home. And we have the interests of property owners who want to use their property in the way they see fit. And we also, aligned with them, we have visitors who have interests in having a home-like setting when they visit. And so if we had perfect enforcement, all we would have to do is implement that, and we could meet everybody's desires and goals. But for me, having done my best to learn about this, I don't think that perfect enforcement is attainable. And that's not through anybody's fault, it's just the nature of the situation. And therefore, a balance needs to happen between residents who want peaceful enjoyment and property owners who want to use their property. Both of those are important to me, and I've tried to keep them in mind as I've thought about this. I have some other guiding criteria for my own use as I look at the questions involved. One is I want it to be legally defensible as much as possible. And I really appreciate Mr. Hames telling us that everything has a rational basis that the VHR Advisory Board has recommended. and I believe that, and I have heard those rational bases for everything. I do feel like some of the recommendations are more legally defensible than others, and I'm not going to substitute my judgment for our legal counsel. This is just my own sense of how closely is a restriction tied to an important concern. I want the end result to be simple, clear, concise. And that's important for me for a number of reasons. I don't want to have administrative costs blow up, especially for things that are not closely tied to a benefit that could happen to improved enforcement, right? So I don't want a bunch more administrative costs that isn't closely correlated with better enforcement. I want there to be common sense. I think if we make rules that aren't somewhat related to what Airbnb or VHR renters have experienced in the past, but are very different, then we'll have people who don't abide by the rules anyway. So I want it to be something that people would kind of expect would be a rule. So those are probably no different than everyone else has used, but it has benefited me to think of these things and to look at every suggested change in light of these principles for me. Thank you.
Thank you. Mr. Strelo, I guess I think the consensus is we want to approach this from the red areas that you've identified, and we'll just go down the list. So,
thank you, Chairman. Ernie Strelo for the record. So the slide is up, number 22. This slide focuses on tier structure. Currently, as noted on the left, we have a tier 1, a tier 2, and a tier 3. The advisory board recommended additional tiers. The purpose of this change is to add focus requirements on mostly former tier 2 items. If you look at page 32, there's another way to represent it in your deck. In the backup is it's more graphical, and it talks a little bit more to the details, like insurance amounts, noise monitor requirements, and lastly, insurance liability amounts. So the structure I used on this slide, it'll be the same structure on the next 9 that we'll go through eventually. So it's the current code is on the left column. The VHR advisory board recommendations are in the middle, and then the PC or planning commission, in this instance, they mirrored the recommendations of the VHR advisory board. So I will pause.
okay. I think it's important for us to indicate that, or at least for me, while I may have different views on the recommendations that the Vacation Home Advisory Board makes, that by no means should diminish the amount of work and time and effort they put into this document. Okay, I hope that's very clear to Ms. Hempler and Ms. Romaine, and I hope they express that to the other members of your board. Commissioners, do you have any comments you'd like to make in regards to the two? And that's what I want to do, is I want to stop at each one of these and allow you to ask questions and make observations, and then try to come to some kind of a agreement from us as to whether or not, where we want to go with that particular area. So Commissioner Tarkanian, looks like you had a desire.
Can I call you Ernie? I have a hard time, Strelo. Am I saying that right, Strelo? Mr. Strelo?
You're doing a great job.
Ernie.
You can
So,
call me
okay,
Ernie.
Mr. Strelo, I just wanted to ask you, is this appropriate time to ask about the differences in the noise monitors? Because you're saying the tiers apply them differently, or is there going to be somewhere else? Yes? No? Let's look at the advisory board.
This is Ernie Strelo for the record. We talked about noise monitors in other parts of the presentation, but you can certainly ask it.
I guess my question is, one, is my understanding they're very cheap. Is that correct or not, these noise monitors?
That's true.
Okay, so why wouldn't we have them? Again, my understanding is, what tier, according to this amendment requires noise monitors, what don't, and why are we cutting it off at a certain number? Is there a reason for that? Because, and let me give you the reasons why I don't think the numbers matter as much. You could have 4 people renting it, and they can have 20 people come over and have a wild party, and they're still going to have the noise that a 6 or 8 person or 10 person occupant would.
Ernie Strelo for the record. I can answer the intent of what the VHR board that I recall discussed. Currently, we have tier 1s, 2s, and 3s. Tier 3s require a special use permit, which also comes with it noise monitors. So that's usually more than 10. In the new structure, they broke out tier 2s to be 3 different occupants, 3 different levels of occupants, up to 4, up to 8, and up to 10. The VHR board decided 10 or more occupants, or in the new code would be tier 3, would require a noise monitor. A tier 2 would be advisory. So if there was a call, they came in and the sheriff came out, they got a big complaint about having a party, as you mentioned, then they could be required to have a noise monitor based on that. So it could be less. So
Let me just cut you off and tell you why that's hard to work. The vice chair of the advisory board stated that 75% of the complaints aren't even reported. And so there could be a lot of these things happening that aren't reported, and so they don't have a noise monitor. And even if you do it after they have had it once, how long does that last for? Is it going to be permanent then? Or is it going to be for a year? How's it going to work?
Well, a noise monitor is permanent. So once you're told or once you require a noise monitor on any house, it would be permanent for renewals until they give up the permit. Is there?
Okay.
Okay.
So, and we've had a lot of discussions over this particular item. I'm of a mind that if it ain't broke, don't fix it. I don't see where the current tier structure is broken. And then it basically, when you change that tier structure, now you get into a lot of other weeds. And I just don't know that we need to go there. So, I mean, I'm not convinced, even in listening to folks in regards to creating 5 tiers versus the current 3 tiers. I don't see that it's going to help us a lot. And so I'm not, I think there's other things that we need to concentrate on other than whether or not the tier system's broken. I don't see it as broken, so I'm inclined just not to go there. But that's my input on the tier structure now. Mr. Rice said.
Thank you, Mr. Chairman. I believe in the theory of KISS. Keep it simple. I'll leave the rest of it to your imagination. We were presented with a package a long time ago that the VHR board task force had worked on, and they presented it to us with a great big red bow. All of the recommendations, everything that they brought to us was logical, rational. And the first thing that this commission did was rip that red bow off and tear the thing apart, and we ended up in court. And we didn't fare so well in that court, as far as I'm concerned. I was on the group trying to negotiate, and we thought we came up with a solution, and then it came back to the board, and then we voted it down. I would like to suggest that we go with the recommendations of the Vacation Home Rental Board. Let it play out. What we have now is working. There's room for improvement, but it is working. I know because I live right around the corner from one of the most notorious party houses. And since we have put these rules into place, it is no longer a problem. They lost their ability to be a Tier 3, and they are now a Tier 2. And in the last 8 months we've had a lot of snow, I understand, but in the last 8 months, we've not had one problem with the party house because they're no longer a Tier 3. If we let this play out, when we have a problem location, the way the current structure is, there are ways of rectifying that. And I don't want to get things so complicated that, number one, somebody applying for a permit has to have an attorney because we have so many rules they can't get through the weeds to find out where the pond is. So I would like to keep it as simple as possible, and I concur. I think the three-tier system is working, and I don't want to get too far into the weeds with that. And since I'm already flapping my gums up here, our family has used VHRs, not here because we happen to have a house big enough to accommodate what we need to do, but we have used VHRs in Anaheim. We've used them in Branson. We have a large family, and we have yet to have a complaint, even though it may say 8 occupants. If we have a couple of places and want to get together for a family dinner, we're going to get over the minimum number of people that are allowed to be in the house. And why should we be restricted so that we have to go to a park to have our family gathering? And I don't like the removal of the or imposition of a daytime restriction. I believe the nighttime restriction is good enough. And if there's problems with the house, the sheriff has been more than cooperative in taking care of those problems. So I'm in favor of going with recommendations for the most part of the VHR board. I don't want to see the 2 per bedroom plus 2 removed, because that takes it away from a family who has enough kids that are going to go over that they can't all be in the same place at once. And I think we're opening ourselves up for another long session in the courthouse. Okay. So that's my feeling.
So I'm unclear where you are here. You've indicated you're good with the current tier system, but this is the current tier system, and then you said you were good with what the board came back and said. So that's why I'm a little bit confused. You're good with the current tier system, 3 tiers, leave it alone. Is that right?
Yes, sir.
Okay. I said, I know that you voiced something earlier. You want to
Yeah, I think I've fallen into that group that somebody said something that made me change my mind. I wish that were not true. But anyway, as I look at this, I'm looking at the current Tier 1, 2, 3. 3 requires a special use permit because of that big group of people. So in order to accommodate that, we've gone from Tier 1 residential host, owner got to be there all the time. And then we got Tier 2 broken up into 1, 2, and 3 based on occupants. I'm reminded of a thing called Roman law that then becomes civil law because we start putting all these nuances into that basic law. Sort of like our Constitution. No, not our Constitution. Our laws under the Constitution. So I'm of the opinion that we should keep Tier 1, 2, and 3 if we have to.
Commissioner Tarkanian, do you have any feelings on this?
I could go either way. I would rather go with the multiple tiers if they were more restrictive on what they required. But it seems like a majority of the board wants to stay with the 3 tiers already. I think 3 of you said that. I got a lot of things I'll fight over. This isn't one of them.
Okay. Commissioner Hales, you want to try to convince us otherwise?
No. I do want to recognize, though, that it was very thoughtfully done, and that it was broken into different, tier 2 was broken into different tiers so that those that have higher occupancy would have more structures put in place, like the 100-foot rule, the local property manager, the noise monitor. So by saying that we are not going to split those tiers up, we still leave on the table, what are we going to do with those restrictions? So I want to seriously acknowledge and thank them for thinking so deeply and in detail about how to do this. I think it's more complex than just saying we want to stick with 3 tiers, because then we have to say, what do we do with their other recommendations on these points? But we'll do that when we get there. So I'm not going to try and convince you otherwise.
Thank you. So I think you have a good idea where we are on the tiers. Is that right?
Ernie Strelo, for the record, I'm very clear.
I want to make sure we're clear to the public, is that we desire an ordinance that keeps the current tier process intact, okay? I don't know how that's going to affect necessarily some of your other recommendations, but hopefully you have an answer as we go through this that can address those. So, okay, so the next item is what, occupancy?
Mr. Chairman, just to be clear, in looking at this first, the tier structure, if we opt to go with 1, 2, 3, and we have a consensus on that, that means that the other 2 advisory board and the planning commissions for changes are rejected.
That's my impression. Yeah. I mean, we don't, and Mr. Tarkini has pointed this out many times, if we have information and feel otherwise, we are not required to move in the same direction as our advisory boards. So, but as Commissioner Hales is trying to explain, that doesn't mean that we don't treasure their input either. So, I think that's very important that we illustrate. So, move to occupancy, I guess, the next one.
Yes, Ernie Strelo for the record. We will move along. So this slide is the calculation of occupancy. There is currently a +2 provision in the code for VHRs up to 4 bedrooms. As a general rule, occupancy is based on bedrooms, 2 people per bedroom. If you have a 4-bedroom home, you can host 8 people. Under the current code, however, if you have a 4 or less bedrooms, you can also implement the +2 provision, which increases the occupancy by 2 additional people. So your 4-bedroom home can now host 10 people. The idea was that smaller homes would have a hard time catering to families, so the +2 provision was designed to make it easier to bring kids along. It is recommended by the advisory board that the +2 provision be eliminated in the new code. The presumption is that this will reduce occupancy totals and make VHR occupancy more closely resemble occupancy of full-time residents. So on the left side, you see the current code that we spelled out. And then the VHR advisory board chose to get rid of the +2 provision, as well as the planning commission.
Thank you. So the observation I'll make there is that this was a big bone of contention, if Commissioner Tarkanian recalls, when we were into the settlement agreement and the +2 option. If I recall, the federal judge indicated that we could not tie occupancy to parking spaces, if I'm not mistaken. And so they asked us, okay, we'll put a parking restriction back in, but we'd like the +2, okay? One of the primary reasons I was willing to enter into that settlement in that regard is, number one, we did get something back in that regard, the parking. But I look at vacation home rentals very similar to timeshares. And for instance, most timeshare programs always have they say it's 2-bedroom and sleeps 6. It's 3-bedroom and it sleeps 8. It's 1-bedroom and it sleeps 4, with always the opportunity to have either a Murphy bed or a pull-out couch for children or something of that nature. A perfect example of that is my wife and I have a timeshare here in Wyndham over on Elks Point Road. And we like the idea of renting a 2-bedroom condo there that me and my wife can occupy 1 bedroom, my daughter and her husband can occupy another bedroom, and we have a couch that our grandchildren, the 2 grandchildren, can use. Okay, so I really like that +2 option. Now, but maybe there needs to be some compromise here in that regard, okay? And so if we're having the majority of our complaints at the 10 occupancy level, and we said that we would allow the +2 with 4 bedrooms +2, so an occupancy of 10. So 8 in the 4 bedrooms and then +2, so to speak, children. Perhaps there's a compromise available there. Maybe if those are where we're getting the majority of the complaints is at that 10 level, maybe we back off and say maybe it should be up to 3 bedrooms +2 or 2 bedrooms +2. Some compromise of that rather than necessarily the 4 bedrooms. There's been a recommendation that perhaps we could restrict that to age, okay? That becomes very, very difficult to monitor in my mind, okay? So I'm torn on this one, guys. I have to admit that, but I just see my opportunity to have my daughter and her husband come up from Lodi for the weekend and have the grandkids there too in a 2-bedroom condo just seems really good. I'm comfortable with that. But once again, maybe there needs to be a smaller restriction or limit. So Commissioner Hales, I see your light's on, so.
Yes. I like the age limit. And I've spoken to folks who are very adamantly in support of getting rid of the +2. And even they say it makes sense to have an exception for kids. And I think it's intuitive. You take your family on vacation. You have a couple kids that sleep on the floor or children who sleep in the room with their parents. To me, that's a common sense thing where the average VHR renter is going to expect to be able to have a couple little kids with them in a bedroom. And so I think it honors the work of the VHR board to say, okay, we'll get rid of the +2 except for children. And I know that some people suggested make it under 16 because then they don't bring their own car. Well, for me, it's pretty unusual for a 16, 17, 18-year-old to go out of town on vacation with the family and drive separately. So I'm comfortable with 18 and under. And I also really support, to me, that weighs heavily on the side of VHR renters, both the property owner renters and the families who want to rent. It accommodates that important principle, which is important to me. So that's where I fall on this one.
Commissioner Turkanian?
Okay, so I'm completely against this. And first, we made the change to the board. I don't know what the vote was, but the board voted majority at least to have only 2 per bedroom without the +2. The federal judge said that he was going to not allow us to count parking, eliminating it, and our county staff said they felt parking was more important than +2. So we agreed to change it and put back the +2, but only if it lasted until the advisory board came up with their recommendations. That was something that was expressly told to us, that we weren't bound by that settlement with the federal judge. We were only bound until the advisory board came back. Well, now they're back, and I mean, I respectfully, I'll say that so we can start off in that manner, disagree with Commissioner Gardner, and Chairman Gardner, Commissioner Rice. First of all, VHRs are not like timeshares. Timeshares, it's my understanding, has to be zoned a certain way. VHRs are homes in residential neighborhoods. And our ordinance, which we're supposed to, it's, in fact, you said it right here, isn't it? This isn't our guiding principle. What's this? Guiding principle? Guiding principle. It is the intent of the Lake Tahoe Vacation Home Rental Ordinance to make the transitory, God, I can't speak at all, I'm sorry. Make the see if I speak faster, I can get it done better. Make the transitory lodging activity permitted by this chapter resemble the existing residential uses made by resident owners and lessees. Well, one of the advisory board members, Keith Byers, sent us, I believe it was an email, or maybe it was in response to, I read the transcripts, maybe it was there too, but he said when there is no renters at his place, there's an average of whatever number of people. But when there's a VHR renter there, the number of people go up to 3.5%. Well, how is that following this guiding principle? And by adding 2 more people to a bedroom, you increase this guiding principle. And again, with all due respect, if somebody wants to rent a home and bring their in-laws, then rent a 3-bedroom instead of a 2-bedroom. If somebody wants to bring a 16-year-old kids, bring it, get an extra bedroom if you're going to. I don't know if there's a shortage of these, but even if they don't, either change the ordinance and be honest about it, that you want to make a profit off these things and this is a business, or follow the ordinance where it says we want them to resemble the residential neighborhoods and limit them to the beds that are in the homes. If you're going to resemble a residential neighborhood, you don't have to add additional people from a bed because you already have the beds in there. So I'm 100,000, 2,000, whatever percent against it.
You're, okay, so you're against the recommendation, or are you against what we, the previous?
I love the advisory board. I'm taking all the recommendations. That's 2 in a row for me that I like.
Oh, okay. So you want to get rid of the +2, is what I'm saying. You wanted to get rid of the +2. Okay. Commissioner Noasad, what's your attitude in this?
Okay. We just now said we're going to go tier 1, 2, 3, period. Now I'm looking over here under the advisory board and I got a tier 4. Where'd that come from? If we're going to fit with what we already recommended in a previous section, then we should continue that into our next section. So I'm looking at the +2 and I'm thinking, gosh, you know, I don't have small kids. I got small grandchildren. If I want to bring my grandchildren along to one of these things, they're not going to be in a bedroom all by themselves. They're going to be on cots or something else, but we should allow for that provision. As to needing a parking space for every 4 occupants, that makes sense to me. In line with the Roman law, civil law, adequate parking does not tell me anything, unless you want to say 1 parking space for every 4 people. So we could include, well, it's already included, houses with 4 or fewer bedrooms, 2 per bedroom +2. If a +2 is used, you need to have parking space for every 4 occupants. I mean, that's pretty cool. So I'm going to say, with respect to the VHR recommendation to delete the +2 provision, I say don't do that, and since we don't have a tier 4, we'll delete that one too.
Commissioner Rice?
I think I made my point clear. I'm in favor of keeping the +2.
Okay. Commissioner Hales?
Just a thought that I forgot to add. It seems that everybody agrees we want families here, that families are not the causers of the violations with noise, parking, etc. And big groups of adults are the problem. So I'm very, very happy with allowing +2 for minors under this scenario. Okay. Yeah, with the 4 bedrooms or less. And I do like the 1 parking space for every 4 occupants.
Okay, so you're recommending we stay with the current process, only that we restrict that +2 to 18 and under? Is that your recommendation?
I like that.
Okay? Huh? Minors, so that's 18 and under.
Well,
Or
I guess 18 is
okay,
adult.
Under,
but
under 18. Under 18?
I would probably go 18 and under, because that, if you have two teenagers, one's a senior in high school, you can stay in a one-bedroom that has a couch, for
Okay.
instance.
I'm good with those, I'm good with that recommendation. I think that, like I said, I think there's room for compromise here, that would still allow the process. So, Commissioner Rice is of that nature.
I am,
Commissioner
sir.
Noasad is of that nature, right? 18 and lower, and Mr. Wright, Mr. Tarkanian is not. Is that right? Okay. So that's basically 4 of us feel like we need that resolution to come back to us, or that ordinance to come back to us with that restriction, Mr. Hames. Okay.
Ernie Strelo, for the record, did you also, did you agree to the 1 parking space for every 4 occupants also? That it's for tier 3, because obviously you didn't agree with tier 4s. Tier 4s would have been tier 3s currently. Currently, it says adequate parking. We don't have a way to enforce adequate parking. And so is it, you know, if they have 8 or 10 people, is it 3 cars, or?
I like if we can be legal about it, we're not going to get challenged in court, you know, then the 1 parking space for every 4 occupancies, I'm good with that, but I just question whether or not we're not going to get challenged in court onto that. But, you know, we were challenged previously, and but if we can try to get that through this time, I'm good with that. The rest of the commissioners, how do you feel? Because parking seems to be one of the big chief issues in this whole process, right?
Mr. Chairman, I'd like to hear from council.
Thank you, A.J. Hames, for the record from the DA's office. So just to be clear, what the advisory board had recommended and what the planning commission agreed with was imposing on special use permits a parking requirement of 1 parking space for every 4 occupants. So still for, say you have a tier 2 permit with 3 bedrooms and you just want 6 people there, you would need no parking, really. Our ordinance doesn't speak to parking unless you're either using the +2 provision or you have a special use permit. And so the parking requirement applies for the +2, and then what the advisory board was recommending is that same rule, the 1 parking space for every 4, that also apply to the special use permits, which would be tier 3, since we're not adopting additional tiers.
You got me totally confused now. We did an agreement with the courts to limit the parking to 1 per 4. That wasn't just SUPs. That wasn't just tier 3s. And we did that, and we eliminated the +2. And we added the +2. Did that go away? Or, I mean, isn't that the rule right now, that they only have 1 parking per 4?
So if you look
4
at
people?
I agree with Commissioner Tarkanian. We need to find out what exactly the current restrictions are, right? So
Settlement. I mean, isn't that, my understanding, the settlement was that we were going to be able to use parking as a limitation to occupancy if we gave back the +2. You're saying now that's not the case except for tier 3, and that's not my understanding, unless it hasn't been implemented that way.
This is A.J. Hames again for the record. It's tier 3s, which are the special use permits, and any other VHR that utilizes the +2 provision. So there are no parking restrictions if you do not use the +2 provision. The settlement reached was if you're using that +2 provision, that's fine, but we're now going to care about parking. So that's how the code currently reads. What the advisory board is recommending is that rule that currently applies to anyone using the +2 provision, that also apply to special use permits, because currently special use permits don't require any set number of parking spaces. The code only states that you need adequate parking. So if you have a large home and you apply for a tier 3, technically it's not 1 per every 4 people, it's just adequate. So to clarify parking requirements for special use permits, the advisory board is recommending that you take that rule that's already in place for +2 houses and that you apply it to special use permits.
I can concur that. I don't have any problem with that
Agree.
whatsoever. right?
I
Commissioner
certainly
Noset, Commissioner Tarkanian?
Agree 3 in a row with the advisory.
Okay.
Well, let me
Okay,
just say
so
one thing.
you good with that, Mr. Rice?
To
Okay,
not-
so we stay with the current occupancy, right, of +2, but we also add the parking requirement in Tier 3, the existing Tier 3, right? Of 1 parking space for every 4 occupancy. Is that where we are? Okay, thank you. I think that's good. Thank you. How do you feel, Ms. Romaine, about that? Okay, so the next one?
Ernie Strelo for the record. So this one is on occupancy limits that addresses the current no limits criteria for Tier 1 and 2 daytime occupancy and the 50-person daytime limit for Tier 3. The advisory board recommends that occupancy limits of the permit apply 24 hours a day. One caveat to this proposal is the 1-year grace period the advisory board recommended for those who already had reservations on the books. This was to accommodate groups who have already planned gatherings such as graduation party or wedding party at any location.
I had one clarification on that, if you don't mind me jumping in before we talk about the issue. When did the advisory board discuss eliminating, making the occupancy apply across the board? Because at that point, the public was aware they may not be able to continue to have unlimited. So I think if we're looking at an extension, it should be from when this was brought to the public's attention, not the date it's finally ratified in May.
Well, I'm guessing, but it seems to me around November that it was talked about. It could have been earlier, it could have been a little bit later, I can't remember. So the current code for Tier 1 and 2, which is the resident occupant and the up to 10 occupancy, doesn't have a limit in the code. I don't know if that was intentional or not in the past, but it doesn't have a limit. The Tier 3s have a 50-person limit during the day. And then the new code from the VHR advisory board would to eliminate the occupancy, the extra occupancy period, and for it to match the permit. And in addition to that, as you just asked a question on, eliminate it, have a 1-year sunset on it. So that's up to you guys. So.
Yeah,
Mr. Chairman.
Mr. Noset, go ahead while I gather my thoughts.
All right, we're looking at occupancy as a universal term for no matter daylight or night. There should be a difference in those two situations. Occupancy limit applies to overnight guests only. Then you say occupancy limits applies to VHRs at all times. You have to make a distinction between night and day on this one, I think.
I don't think you need to make a distinction. I think you need to protect the residents and these homeowners. And if you allow them to have a large number of people during the daytime, it's going to cause just as many problems with the noise and the trash cans. I love the VHR proposal. Again, I'm 4-0 now for Ellie, who said I wasn't going to support you. 4-0. The only thing and I'm going to say this, is I think it should go back to the time this was brought to the public attention that they may eliminate the 50 people. And I think if you're going to have a grace period, it should go back to that time, not the 1-year period when this will be approved, I think, in May.
Okay.
That's my opinion on this one.
So what I would say is that I think we may have overlooked this when we were looking at the original ordinance a couple years ago. I think maybe that was an oversight. As you indicated, that's a good observation, okay? Now, how many of the Tier 3s currently, do you have any idea how many are actually using their property to that extent where they have 50 guests during the daytime while they do not have that capacity overnight?
This is Ernie Strelo for the record. Well, I know for one is not overnight, but during the day, there's one property that tends to have that occupancy hit a lot.
Okay.
that I'm aware of. I'm not aware of too many others off the top of my head.
Okay, so we're basically, by making this restriction, we're affecting one property, not all 11, I guess. Is it 11 tier 3s we have? Okay, so we're affecting one of those. So I don't want to be so strict on this that so for instance, two families, for instance, my brother's side of the family and my side of the family, I would think that if we're renting two vacation home rentals up here, that we should have the ability to congregate that whole family in one unit during the day for breakfast, lunch, dinner, or family activities, game night or something of that nature. So, the 50 seems to me a little bit excessive. So, once again, I think we need to work out some type of compromise here on this one, recognizing that and I also, and as I understand it, this 50 occupancy tier 3 is a wedding venue. Is that what I'm gathering also on this?
This is Ernie Strelo for the record. When it first started, it was. I think now what they're doing is they've changed it so they rent the VHR and then they're allowed to do things on their own at no cost, or they don't use Tahoe Blue to book through for that type of stuff, as I understand it. So they can do their own weddings or graduation parties or whatever at that property. Beyond that, I don't know.
And I know this is Mr. Kaplan's property, is that right? 650, 750 Tina Court or whatever that was. Do they have current bookings for the year? Because that's if people have made deposits, a year out, then I don't necessarily want to restrict that. So I understand the purpose of the sunset is to say, from the time we enact this ordinance, then you have a year that you can still entertain or honor those contracts. But if it's just, I don't know. I'm asking for some input here.
Ernie Strelo, for the record, Mr. Kaplan is in the room if you want to have him come on. I don't have any information on what he has booked right now.
Perhaps, okay, maybe we can have Mr. Kaplan address that issue or that question. Because this is the only property, as I understand it, that's would be affected by this. Am I correct?
Well, it would affect all 11 properties, but this is the only one that I hear about all the time.
That's current.
Yeah.
Okay.
Thank you. Per Commissioner Tarkanian's observation, once this became public and we realized it was likely to pass, we stopped all bookings of over our nightly occupancy of 14 past 2023. But for the next 8.5 months, we do have lots of bookings still. And these are bookings where people have, especially the ones where they have weddings, where they're all small and they're intimate and we control them, but they've put a lot of money into travel for their guests, and they may have put money to their vendors, and just the trauma, if they were canceled would be enormous.
Thank you. And I heard the input from your fellow residents there that you haven't caused an issue, but still we need to be respectful of the other folks. Commissioners, do you have any other questions of Mr. Kaplan? Nope. Or this item?
No questions, but oh, whoops, sorry, Walt.
No questions for you, sir. I'm looking at the daytime occupancy. It says occupancy of 50.
We had some direct questions in regards to bookings, Ms. Dingler, and that's all I wanted to find out is. I think we've identified the commercial aspects of the ability to do so. Am I incorrect, Mr. Hames?
AJ Hames from the DA's office for the record. There was At the outset, as Mr. Strelo indicated, it did appear that they were operating a commercial business. They were offering services, wedding services online that you could book. And those have been removed, and so they now operate as a VHR. People, as I understand it, have to host their own events and gatherings and things like that.
Can I ask a question on this? And I don't know, maybe you need Mr. Kaplan, but when he promotes these VHRs, is he promoting them with that they have the ability to run weddings there? And if he is, isn't that just a way to circumvent the Douglas Code that prevents these type of activities in residential neighborhoods?
I think part of that, this is AJ Hames again for the record. I don't know what his current advertising is. Me personally, I don't know.
I think we need to, Okay. Sorry, Steve Kaplan, for the record. In July, the county asked us to change our advertising. By the way, in terms of the events, there were always very small fees, and they were never to make money on it. They were to compensate for the extra trash and the laundry and the wear and tear and so on. So we've never made any money from the wedding business. Our whole business is the VHR. And in July, the county asked us to change our advertising. We stopped all advertising for weddings. We took all the event stuff off immediately. And so no, the answer is we don't advertise those.
I guess you just made a great statement that I had a question on that. Do you charge the same amount for VHRs for everybody who rents, or does it vary based upon what their intended purpose is?
We charge the same amount for all stays.
So, Ms. Dingler, I wouldn't mind having you come to the microphone because I have a question for you. So my question for you is your issue with the activities and the noise and the disturbances to your neighborhood, or is your issue with the legality of operating that business? There's a real difference there. Okay.
And I have a two-part aspect to answer to that. The first is, yes, we have DJs that I've had from 10 in the morning to 10 at night. You have them come on and you call the cops and they don't turn up to hear them. So there's nothing really done as far as code compliance. So that's a big issue. The other issue is the legality, because if you look at the documents I sent you that proved as of 9/4, he had already had all of these reservations to the end of this year, okay? At that time, he was working as a commercial wedding and event center. So he was taking whatever fees at that time for booking, which were different numbers. And so at the time that all these bookings came aboard, according to what I see document-wise, I'm speaking of documents here, shows me that he was working as a commercial wedding and event center, taking different fees from different people for different amounts of things, and he booked all of these while he was being a commercial wedding business. So he's still running a commercial wedding business.
Okay. So I think we need to really identify the legal aspects of this and whether or not Mr. Kaplan is operating illegally. That would resolve that issue. But what I heard from your other residents that live very, very closely to his property, they are not experiencing any disturbances. So that's where I struggle, If I have 10 people come before us and say no disturbances and they live right next door, and I hear you saying there is disturbances, then I think there's remedies for you to go through code enforcement to address those concerns. But I'm not hearing that out of the other residents in that area, and that's where I struggle. And whether or not it should be operating as a Tier 3 or a Tier 2 is not up to this board, it's up to the Vacation Home Advisory Board. So those are some decisions that they need to make along with Mr. Strelo. So, but I would like to get I really would like our Mr. Hames to look into this legal aspect, because I think we really need an answer to that. Maybe you've done that already.
This is AJ Hames from the DA's office for the record. Code enforcement did conduct an investigation last summer, and that's when they determined that it appeared he was in violation of his zoning by operating a business. And so that's when notices went out, and that's when he changed his advertising and the structure of his operation to the point where now he just operates a VHR. From what code enforcement is able to find, it appears he's simply operating as a VHR.
And that's the key, okay? Is he only advertising his home as a VHR, or is he advertising his home with the implication that you can host your weddings there? Because all that is circumventing the zoning, the code that you just said that you made him change by. I mean, and is our intent as a board to allow people to use our codes to circumvent the intent of what we want done?
This is AJ Hames again for the record. Well, I think that the advisory board felt that this was a bit of a circumvention of the code, which is why they had recommended a reduction in daytime occupancy. And so certainly that's not the only way to deal with situations like this. And I think we're talking about more than just one house, although it is a good example to use so that we can kind of wrap our minds around the concept. But if there is a loophole in the code and this board perceives it to be a loophole, then the board can then decide, should it be filled? Should that go away? And one way that the advisory board was recommending as a way to deal with situations like this was to just reduce daytime occupancy. And they were recommending a occupancy that is consistent night and day, a single occupancy level. Now, there was some discussion in the Planning Commission, and you've got the minutes in your packet there about some alternative proposals, maybe a 200% daytime occupancy or a plus 25, or there's any number of different ways of looking at this, but that would be up for this board to decide, one, is this a problem that should be addressed? And if it is a problem, how should it be addressed?
And may I just say, a neighbor of mine, Bernie Hittner, at the meeting in which we were trying to eliminate VHRs, he put a written document in there about the disruption to his life.
Okay.
So it's not just me.
Okay. Thank you. I appreciate your input. It's important to listen to both sides of every issue. So, once again, I think that personally, I feel like the occupancy level at 50 is excessive. I really do feel that way. But if they're a tier 3 and they have an occupancy of 14, I don't know that going to double of that to 28 is unreasonable. But I think this 50 is way out of line personally. But that's my gut telling me that. Commissioner Nolasad, you had.
Okay, I'm going to bring this up, and it seems kind of mundane against everything that's been said so far, but I'm looking at occupancy 50, and that requires, according to what we said earlier about parking space for every 4 occupants, that's 13 parking spaces. 13. Keep that in mind.
Nobody is saying they can come by even if
Okay.
that's not how many.
Commissioner Hills, what's your observations, please?
First, I want to note that the Planning Commission, I want to thank the Planning Commission. I want to note that it says no consensus. I think perhaps maybe no action would be more accurate, that they had a short period of time, short meeting in which to discuss this, and not every issue was fully discussed or acted upon. I just wanted to make that observation and thank them for their work. My second, more specific to this, is I would be in favor of sunsetting the 50 person at the end of the calendar year. And finally, on the occupancy during the daytime, to me, this is one of those situations that falls into the common sense category. That if you have too many people to stay in one VHR and you abide by the rules and you get 2, like maybe there's your family and your brother's family, it's not gonna really be natural for VHR renters to check the rules to see if they can have some other person or family over. They're gonna think that it's okay to have a barbecue with these other folks. And so I think double the occupancy is maybe a good way to go about that, because more than that, you probably would be overrunning the property, and you would risk other noise and matters that you don't want to have.
Mr. Rice, how do you feel about those compromises?
I like it. I think that to allow them to have no more than the nighttime occupancy is a little draconian, and I think that we're violating the right of assembly. I do believe that by being reasonable and saying double occupancy during the daytime is reasonable. I'm gauging by my family, sorry about that, in what we have done in the past. But I don't think that by having our families combined for an event has caused any problems for anyone. And I think that double the occupancy during the daytime hours is more than reasonable.
Commissioner Nosad, you have your light on.
Yes, with respect to no consensus, that's one of the possible outcomes of that. The other outcome is if we had a 3, and 1 abstention, that's no consensus. I stick with my position that says with 50, you got to have 13 parking places. So if you go to 25, you got to have 7. You got 7 up there? I don't have 7 parking places in my house unless I open my garage.
Okay. Commissioner Tarkanian, Ms. Romaine.
Lauren Romaine, thank you. I'm having difficulty because I'm sitting here and there's so much rationale that we talked about that we're not being able to get to you. None of us have a problem with families coming together. The issue is in Tahoe Township, we don't have parking. Parking is the #1 problem. So you already have a place that has 5 people. They bring, 10 people, they bring 5 cars. Now when you allow other people from another one to come in, it inundates, and we have a residence where all the full-time residents are allowed to have 2 vehicles only. And then these VHRs come in with 5 cars, and then they bring in more people. So none of us have a problem. All I'm asking is that if you do this to this, could you please have something that says, and you must abide by all parking restrictions and cannot exceed those? Thank you.
I think those are reasonable observations to me.
I guess I got a clarification because I may be confused. We require occupancy limits to be limited based upon parking. That's one of them. But right now, during the daytime, can they have guests that come over that there aren't parking spots? Okay, so what you're saying then is they can have 50 people come by, still be following the rules because they're guests, they're not the occupants. So what are you proposing now to say you can only have so many guests that could come by that fall under the parking availability? I was asking you, Ms. Hepler, because I don't see how, if you don't count the guests coming by, how that's going to solve your parking issue.
Can I speak to that? I think you have Uber. I think you have the guests in the one home go pick the other ones up. I think there's ways to solve this that don't necessarily end up in parking, and I think it's a great idea to emphasize that you don't get more parking if you have guests come over.
Okay, so I think there's ways that we can massage this, is what I'm hearing. I want to ask a question in regards to the operating hours, okay, because the hours play into this as well, right? What times are they allowed to do this? We say no overnight stays, but at what time does the occupancy need to drop back down to the permit holders' maximum limits?
Ernie Strelo for the record, 9 p.m.
And what about in the morning?
8 a.m.
8 a.m. So from 9 p.m. until 8 a.m., they're still they're restricted to the maximum amount that are allowed in that permit. Okay, so I feel like there's some massaging we can do with this.
I just need to figure out exactly how this works again. So you're saying that if someone is restricted to 14 people because of the parking. If they have guests come by, the guests cannot bring cars, or they're in violation of the VHR code. Is that what you're saying? You looking at me like I'm crazy. I'm just trying to figure it out.
I'm trying to figure it out as well, so don't, you know.
I hate to say, I'm a bit confused too, but the cars, that only time that you look at cars is when it's on the tier 3. We don't look at parking. So you can have an occupancy of 14 because that's a 2 per bedroom plus 2, and you could have only 2 parking spots. It doesn't come into play. Am I right? It does. I'm sorry. Well,
This is Ernie Strelo for the record. Every resident that comes up for renewal or a new permit has their garage checked, their driveways measured to figure out how much parking there is, and that is the limit of their parking availability. They can't come up with another 10 because you increased the occupancy during the day. If they have nowhere to park, they can't park there, right? And so it's not just a tier 3, it's a 1, 2, or 3.
Occupancy is not tied to any parking. So you can have 4 bedrooms plus 2.
I'm sorry, it appears that our attorney has something to say here.
This is AJ Hames from the DA's office for the record. So there's parking restrictions and then there's occupancy restrictions, and sometimes they are related, but not always. So for instance, your occupancy is based on bedrooms, and if you're using the +2 provision, it's also based on parking. But separate from that requirement, there are also parking restrictions, just generally.
Yeah, I was going to say, but hold on. Let's not do the +2. Let's just say they're not using the +2. They have 2 parking spots. They're limited to 4 people then, right?
So if you have a 2-bedroom place.
Or 8 people. Is that what it is? Is you have 4 per car?
So if you have under our current code, if you have 4 bedrooms and you're just doing 8 occupancy, then what happens is you can get your 8 occupancy regardless of how many spaces you might have available. But Ernie will go up to your house and he'll actually measure and figure out how many spaces. So then he will issue you a VHR permit that says 8 occupancy, but it might say 1 parking space. And so then your permit requires you, based on the size of your lot, to have 1 space. It's not related to occupancy, it's separate from occupancy at that point. So it's a parking restriction based on size, but it's not based on occupancy. So then with parking, we often combine them, but they are in many ways distinct. So you can have an occupancy of 8 with 1 parking space. That is allowed under our code. And then technically, if you bring 2 cars, you're in violation of the conditions of your permit, and the individuals who parked illegally could be fined $500, and also the owner of the VHR can be fined $1,000 for the parking violation. It's not an occupancy violation, it's a parking violation.
So I'm going to tell you, my son says I'm forgetting things, and either I'm forgetting things or you guys wrote the code up different than we discussed in 2000 and whatever year I was on a 20. One of the main issues we talked about, and I thought this was something Ms. Davidson thought was the most important, was to only allow 4 occupants per car.
That's true of the +2 houses only.
But we had that before we made the change with the judge. What we approved originally, is my understanding. Am I wrong?
No, you are correct. The code originally had the parking. The judge didn't like it, and so as part of the settlement, we made it only applicable to homes that were using the +2 provision. So parking relates to occupancy only for those homes.
Well, that was misrepresented to me in our settlement. I understood that we allow the +2, but we only allow +2 if there's additional parking. It didn't mean we were going to allow 8 people for 1 parking spot to replace it. That was never the intent or told to me. And I certainly wouldn't have approved 8 people to come in with 1 parking spot because it's unrealistic. They're not going to do that. They're going to park illegally.
You could change that. That is one of the things that we are hoping to get guidance on. But as written, there's parking and there's occupancy, and they are not necessarily related.
Okay. So what we're discussing here is daytime occupancy. I feel like 50 is excessive. But if there's already bookings, then I think we need to let those bookings go through rather than default. So I don't have any problem. I like what Commissioner Hale said, is we would sunset on December 31st of 2023, so that the parties involved would understand that they can't book anything beyond that date of December 31st of 2023. And I like the idea of perhaps going to a double occupancy that currently exists, as long as parking allows for that process.
That's my clarification. Can you tell me what you mean by that? Because that's the difference between my vote and yes or no, which may not matter. But I'd like to figure out what you mean by that. And I tried to use that example, but I don't think it was accepted. So occupancy allows you to have 12 people and you have three parking stalls, right? 4 there. So you're telling me you can't have 12 more people come unless there's 3 more parking stalls? Is that what you're saying, or is there something different?
I'm telling you that whatever we do here on occupancy is going to be violated anyways. It's going to be violated. You know, somehow it's going to be violated. People are always looking for loopholes in our laws. And that's not just our jurisdiction, that's in all jurisdiction. Okay? So what is reasonable? What is reasonable expectations? That's you know, and heck, if and I've used that word heck, if 100 people showed up at a property and nobody knew it, how would they know that there was 100 people there? It only becomes a violation when they have to call code enforcement. But I don't want to go to that extreme. I would like to see some reasonableness here and some, you know, can we get to some kind of compromise? And now I understand, I'm beginning to understand, if I haven't already, how difficult it was for not only the Vacation Home Advisory Board to do this, but also I can now see why the Planning Commission couldn't come to any kind of consensus on this as well. So are we going to be able to come to some consensus is the question right now.
I want to answer Commissioner Tarkanian's question. In my mind, we say you can have people come over during the daytime. You get no more additional parking. If someone comes to visit as a guest and their vehicle doesn't fit within the parking, they get the $500 fine. The owner gets the $1,000 fine.
Thank you. That's all I was
see it.
asking for clarification. That's so wonderful.
But the answer was made quite well by the young lawyer over there. Somebody's going to come out and measure your property and see how many vehicles will fit on that property. Period. Roman law, civic law.
Do we have some kind of consensus here? You know, what, Commissioner Rice?
Mr. Chairman, I'm glad we don't have any babies to split up here. This could get really messy. I concur with you that the daytime occupancy could reasonably go to double. And as I understand it, the occupancy versus parking spaces are not intertwined. That you're allowed this many people and you're allowed that many cars, period. And it matters not how many bedrooms, but how many places there are for cars to park. Is that correct understanding?
Yes.
Commissioner Turk, are you good with that? Since we say sunset December 31st, 2023, up to 50% or up to double, as long as it doesn't violate the available parking spaces that are assigned to the unit. Is that where we're going with this? I think you could craft something into that, Mr. Hames?
I would dare say that if you try to do that, you're going to get success 0% of the time. I mean, in terms of this or that. Well, the thing's going to be measured out for X number of cars, not X plus 4.
And that will be the purpose of Mr. Strelo. When he visits a property, he's probably going to say, okay, this house, tier 3, can handle 12 people, but it can only handle 2 cars. Okay, that's going to restrict that. And those 2 cars don't double the amount of people that can be there during the daytime.
Ernie Strela for the record. All permit renewals indicate parking spaces available at a home, regardless of tier.
Is that enough direction for them on this one?
Aye.
Okay, I think you have some direction there.
I'm still confused with the doubling of daytime. I don't care if you're going to go from 1 to 2, as long as you got the parking space there, according to the measurements taken by the board.
Did we have something else to share? Or no? Okay. Are we able, what's the next level? Is that, are we looking at density? This one can be interesting. Yeah.
This is the one that you've been waiting for. Ernie Strela for the record. So currently today, as you're all aware of, there's a 600 resident cap in Douglas Town, in the Tahoe Township. Single-family residential has a 15% cap. Multifamily homes have a 20% cap. And Tahoe Village, for this conversation, has been separated out, which is over by Heavenly. That's where the timeshares are. Is currently at 20%. And then there's 2 or 3 neighborhoods that have HOAs that don't have current issued VHRs, so we don't include them. We don't issue permits at all to them. The advisory board, more in the motion of fairness, is suggesting that the single-family residential and the multifamily be coupled both at 15%. So Pine Wild, Beach Club, et cetera, would become 15% from 20% today. And then Tahoe Village would be doubled to 40%. And the thinking there is, why not 100%? Because there was discussion about not having VHR owners dominate the HOA board. So 40% was the consensus there. And then on the Planning Commission, and they did come to a consensus on this somewhat, they had 20% and 20%, so they actually wanted to increase it for a single family and multifamily. Well, multifamily would say the same. And in Tahoe Village, they agreed at the 40%.
Thank you. It's just funny that 2 years now have gone by, and I originally proposed 15% on single-family and multifamily residences. You remember that, Mr. Noah said, Mr. Rice, Mr. Tarkanian, and I couldn't get any consent buy-in on that whatsoever. It was all me. I was standing out there kind of on an island by myself on that. And now the VHR board has come back all full circle to that concept of 15%. I didn't feel like we should treat single-family residences any different from multifamily residences or vice versa. So, and I know that Commissioner Tarkanian has, for a number of years, fought for the 40% in Tahoe Village, right? So I'm comfortable with this. Now, the real question is, and I was hoping that the Vacation Home Advisory Board would go deeper into this density level and look at individual neighborhoods. So, and I know that Commissioner Tarkanian has some ideas on that, so I'd like to listen to those, and Mr. Noah said has some as well.
First of all, I'd like you on an island by yourself, but you weren't on that issue, because I said, I didn't say 15%, but I said we shouldn't distinguish between the multifamily residential neighborhoods. I don't see a difference in it. In fact, I actually think it's harder to have more VHRs in a multifamily neighborhood because they're on top of each other. Okay, I got 6, maybe 7 questions, okay? They're not gonna be all nice, but they're gonna be quick. Okay. Are you aware of the proposal I made to the, I made for VHRs on Lake Tahoe?
Yes, I am.
Was the advisory board aware of the proposals I made as well?
Yes.
In fact, I sent you and the chairwoman an email about my proposal on December 14th, correct?
That's correct.
Well, the editor of the Record Courier indicated that I had not presented my proposal to the advisory board. Did that come from you?
No.
You aware if it came from anybody from the advisory board?
I'm not aware.
Can't believe Kurt would make that up. How much time did the advisory board take on my proposal?
According to the minutes, not very long. It was about a half a page of the minutes.
I saw about 2 paragraphs, okay. Now, we've talked about, Commissioner Hales, about your extensive review of each neighborhood and the proposal that you made. Is your recommendation part of this packet? How long did the advisory board discuss your recommendations?
So it was presented last July, so they sat through my presentation, and then I think it was brought up, it was in the packets a few times, but I think that the focus was more on the fairness of the neighborhoods.
So really, there was very little discussion on this type of density. What it basically was, and I don't disagree with Ms. Hempler, I want to make sure I get it right what said. In the minutes of the January 11th meeting, you said it's hard, almost impossible to go over this density issue if you want to get it on the board by May. But I mean, we waited a year and a half. I would have preferred to have you done something and at least maybe left density off until you came up with it. But either way, nothing's ever been discussed and on either one of these 2 issues, basically. So I'm going to go back to your guiding principle here. First of all, do you believe it is important to follow the Board of County Commissioners' direction and guidance with respect to VHRs in Douglas County? Say yes.
To me,
Yes.
does Ernie Stroh? Of course.
Okay, and do you think the advisory board, and do you believe the advisory board thinks it's important?
I do.
Okay, so I'm gonna go back to the guiding principle deal, okay? I mean, again, we just ignore this. This is part of the ordinance that we passed. Everybody wants to follow the ordinance, but we ignore this. It is the intent of the Lake Tahoe Vacational Rental Ordinance to make the transitory lodging activity permitted by this chapter resemble the existing residential uses made by resident owners and leases. Okay, so after the Glenbrook Homeowners Association banned VHRs, which they did, to anybody outside the HOA, I sent you and the advisory board, actually 2 emails because I didn't get any responses back. And I basically asked, what factual basis do you have to allow VHRs in 54 homes outside the HOA when the other 184 homes in Glenbrook ban them? Did you respond back to me?
I must have.
No, you didn't.
I didn't respond to you. Okay.
I get used to that, though. My wife never responds to me. It's just a typical thing I get used to. And nobody on the advisory board did except Ms. Graff. She responded back saying, well, the Glenbrook deal was an anomaly because there was one disgruntled wealthy guy who has a second home there, and he's the one who fought all of it. But she never said why. So, I'm trying to figure out, if we're talking about density, shouldn't one of the most important principles be what we just stated here as a guidance? Well, I think then when we're talking about all of these residential neighborhoods, that a flat 15%, you're treating all of them the same, and you're ignoring this. Now, I would much rather have 15% than 20%, and I don't think you make a difference between single-family residential and multifamily, but I certainly believe the neighborhoods are different and they need to be treated differently. I just use Glenbrook as an example. You're going to have 20% of the neighborhood allow VHRs and 80% not. That's it.
Thank you. Commissioner Nosad?
Just as a reminder for you, sir, we talked about the 15% cap, or density rather, and at that time we thought, well, maybe this neighborhood deserves a 13%. Another one deserves a 12, another one deserves a 20 or a 21. That was what the issue was. So I think this ending up at 15 and 20 was what we decided on, but I'm going to go along with the 15, 15, and 40 for Tahoe Village.
And I already said that I concurred with that, so that's where I am. Commissioner Hales, what your input here?
Here are some concerns of mine. It's hard to enforce occupancy restrictions. It's hard to enforce parking. We don't have control over those things. As much as we wish we could eliminate the bad actors, we don't have control, and we won't have control. That's not going to change. What we do have control over is the number of permits. So I think we need to be very mindful of how we do this. I feel there's I like your chart. I like your chart because it's tied into facts. And I think it's fair to treat one neighborhood different than another if the streets are wider and it has more capacity for more people to be staying there. So I'm not saying I would adopt these exact percentages, but an approach that recognizes the differences in neighborhood would be something I would be more in favor of. And then I would take less nitpicky rules about you have to have this, you have to have that, because we have reduced overall the numbers. I think that's a more defensible position than having a blanket percentage across all neighborhoods. So I don't know how the rest of the board feels about that, and I don't know what it would actually mean. Could we remand it to the VHR board to consider neighborhood by neighborhood? Do we give it to you to figure that out? I sense that except for me, because I'm here with fresh energy, everybody else wants to be done, and I respect that. But if there is no neighborhood by neighborhood approach, and I have to decide between 15% and 20%, I am so sympathetic to those tiny neighborhoods with very narrow roads, and I'm worried about them, that I would have to go with 15.
Commissioner Rice, I don't think you've weighed in on this issue yet.
Thank you. In looking at the chart, with density as it is now, I don't see where any neighborhood has been inundated that wasn't designed to accommodate these sorts of rentals or BHRs. Tahoe Village, it's my understanding, now I've never stayed there, I've skied there, but I haven't stayed there. I wish I could do that some more, but I can't, never mind. Anyway, it's my understanding that many of those houses were not designed, or many of the residents there were not designed to have full-time occupancy. And I've been told, and not seen, but been told, that some of these units don't even have closets, that they're designed for people to come in, ski in, ski out, live out of your suitcase, have a nice time, come visit us again next year. So I think 40% up there is I was tempted when my wife and I first moved here to get a condo up there, but we've been in condos before, no thank you. But I think that the...
Be careful, she's right here.
Yeah, I know. I have to go home tonight. It's my belief that 15, 15, and 40, it is more than reasonable. And if at a later date we have to revisit, then we can do that. But I would like to see something in place, in concrete, where everybody can depend upon what the rules are and not be fluttering around in limbo land like we are now. So I'm perfectly happy with 15, 15, and 40.
Okay. So I have a couple of questions, Mr. Strelo. Number one, and when we first put these caps in of 15 and 20%, and you broke out Tahoe Village for this purpose of the chart, but when we did that, we indicated that I think originally we had only about 27 identified neighborhoods, and we asked the question, how many of those 27, and I'm just using round numbers there, how many were already over that 20%? And then we felt like it was only appropriate to, if it was above 20%, that reduction would only happen through attrition, not by trying to figure out who we were going to take a permit away from. So in that regard, can you tell me where we currently stand on single-family residences by neighborhood? You have 39 neighborhoods now. how many of those 39 are over the 15% cap currently?
You're asking me to remember things. I have, Ernie Strela for the record, I have 6 neighborhoods that are at or over the limit right now, either 15 or 20%. Tend to think that it's split two ways. You know, it's 3 15% and 3 20s on the multis.
Okay, so I think, once again, I think our intent here is not to strip anybody of their permit, so it only happens through attrition. So you're saying of the single-family residences, is about 3 neighborhoods, about multifamily residential neighborhoods, about 15%, a little, maybe 3 of those, and then Tahoe Village. What's the current, what is the current percentage up there now?
Ernie Strela for the record.
That couldn't be above 20%, right? Because that's what our rule is 20%.
Ernie Strela for the record. Actually, they're at 14% right now.
Okay, so there's some room to go up there. Okay. Do we have?
I think 9.
Okay, so 9 plus because they're not included in the 535 number is?
I think I included them on one slide, but yeah, they're not included.
Okay, so it's not gonna absorb the remaining 10% of available permits.
No.
Right, okay. So, commissioners, and I kind of, you know, I've looked at this, Ms. Hales, as well, and I was hoping that our Vacation Home Advisory Board would basically take a closer look at Mr. Strelow's recommendations in regards to the density levels by neighborhood. I still think that that's hopefully something that we can task them to do in this next year, because I don't think we're done with this ordinance by any, you know, we're going to have to review it from time to time. But I would hope that, because I do believe that there are some neighborhoods that maybe shouldn't be at 15%. And maybe there's others that need to go above the 15%, but that we need to identify those individually, in my opinion, based on all the conditions around. Anyways, but I know you had just a tremendous amount of task, and so I respect that as well. So I thought that this was, I feel like this is a good proposal, and I think that we should go with it and feel it and see what it happens, okay, for a while. So,
how about the cap?
Huh?
Have you thought about the cap?
I've thought about the cap.
Leave it alone?
I've thought about the cap.
You have?
Yes. How many permits do we have out right now?
All in, I have around 535, tier 1, 2, and 3.
Okay, good. That's what the question was. So, and we got a cap of 600. I would suggest that we drop that down to 535. And as people fail to reapply, it goes down to 534. That may be a way of extricating ourselves from the density issue.
Well, I'm comfortable with the 600 number. You know, I want to see what happens in Tahoe Village, so that may absorb the rest of those. I don't know. I think there's room to grow up there, and so I think the 535 would be a little arbitrary based on by changing this to 40%. We may soak up a huge percentage of those. So I say we stay at 600 and let it play itself out and see where we are in perhaps another year.
All right. Given the situation at Tahoe Village, which is what is that Heavenly? No. It is. Okay. Fine. So we were admitted that that is a timeshare. And by the way, Commissioner Rice, I agree with you on timeshares. I had 3 of them, and then I gained my sanity. I sold them. Okay. The 40% in the Tahoe Village, I think that's arbitrary because of the situation. There's 2 buildings and lots of apartments, and I don't think that there is need for a VHR in that area. So that would take care of the other 535.
Okay. Okay, let's try to see if we have a consensus on this. Is everybody good with the 15, 15, and 40? Commissioner Tarkanian? 15, 15, and 40?
I don't think this is the right approach, but if you're talking about changing from what we have to this, then I would be in favor of that. But I want to make it clear, so when I do make a different proposal, that I don't think this is the right one.
And I think you have some concurrence on that. You know, I think Commissioner Hales is in agreement that we need to look at it a little bit with a little bit more under a microscope and look at it individual neighborhoods. I don't know that we have a lack of consensus on that idea. It's just how we go about doing it and giving them more time to do that. So, Commissioner Rice, what do you?
Thank you, Mr. Chairman. I don't think that we need to reduce our cap. We have never reached our cap, and we have been advertising for a long time that the cap was 600. I don't want to touch that at the moment. And I concur 15, 15, and 40, and we'll take a look at it in another year or so. Let's see how it plays out. Let's let the process work. Let our enforcement team do what's necessary. And I, for one, at least in my neighborhood, am very satisfied with the results that we've seen. Thank you for my sanity.
Okay, so are we good with 15, 15, 40, leaving the cap alone? And adding tier ones back into the cap?
Yes.
Commissioner Hales, okay.
I
yes.
can live with that,
Okay.
given the discussion, but I do have one other clarification. I would just want to clarify the PC action on this. It says no consensus, but then it says 20, 40.
Yeah, I see that anomaly as well, the inconsistency there. So,
This is,
in other words, okay, Mr. Hames.
Thank you, Commissioner. AJ Hames, to the record. There was no discussion, at least at length, regarding the cap. So there was consensus on 20/20/40, but there was no consensus on whether the 600 cap should apply to tiers 2 and 3 only, or as the advisory board had proposed, that 600 cap applied to all 3 tiers. So that was the other item of possible discussion today. Should that 600 cap, if we are keeping 600, should it apply to just tiers 2 and 3 as it currently does? Or should it also apply to the few tier 1s that exist?
Let's go with the advisory board on this. I think it's just a handful, right? It's just a handful. 10. I'd be fine with that.
So we have consensus that we go with the advisory board's recommendations here, 600 cap, all tiers, 15, 15, and 40. We're all good with that? There you go. Boy, that was a lot easier than you thought, right, Mr. Strelo?
I
Just
did.
reading
I
your
thought
mind,
there would
that's
be
all.
arm wrestling and mud matches, but here we are.
So it's 3:04, and I think we need to use the facilities. So if we can come back at 3:15, that'll give us 11 minutes, right? Thank you. We'll reset 3:15. Okay, it's 3:21, so we're a little bit later. Commissioner Rice, if you want to join us. And where's Mr. Strelo? Oh, there he is. Okay, so we're going on to the next item.
Not to complicate.
622.
To complicate, can I, before we move on, can I add a couple things? Okay. I want to note, when I said we can't control occupancy, we can't implement enforcement of occupancy or parking as fully as we would like to. It was pointed out to me that property managers are perhaps a really good tool to do that. And I think that's coming up later. And I just wanted to correct myself because I overstated on that point. And the second thing I would like to briefly touch on, and another member of the audience pointed out to me that it may have never been covered in public how Mr. Strelo came up with the chart. And if he could tell us in 2 minutes how he came up with the chart, then that would sort of support this idea that perhaps we should ask the VHR board to look more closely at that and bring us back something.
You do know Mr. Strelo, right? I mean, 2 minutes is setting a very high
Oh, he's fast. He can do it.
I'm not a
Mr.
commissioner.
Strelo.
I could talk pretty quick. Ernie Strelo for the record. What I did is I went through each of the neighborhoods in the Tahoe Basin. So we identify them as 39 different geographical locations on the map. And one of the big things that we looked at, or that I looked at, was the parking and the street parking. If there was street parking, what an average driveway was. Was it wood? Was it an actual driveway? And then road width and kind of the road conditions. So, like if you're in the Kingsbury area and you're in the mountains there, there's a lot of bends and stuff like that. So the roads might be either wider until you get more into the artillery, into the deeper sections of the road, and they shrink. Or if you were along the Lincoln Highway, which most of those neighborhoods were constructed over almost 100 years ago, I think. And so the parking is very limited. So for instance, if you, in the packet, I have pictures of Lincoln Park, and I didn't think that it would make sense to have more than at least 5% in that neighborhood because the road is narrow, there's no parking. And in addition to that, if I were to drive my pickup truck down that road right now, I'd lose mirrors, right? So there's just not enough room to drive down those kind of roads, and people bring SUVs and trucks or whatever up here, to rent. And when you go into a lot of these rental sites, you don't know exactly the address of the house that you're renting until you rent it. And so, it's kind of sight unknown in some cases. And so I used a Likert scale, to start grading on a 1 to 5 scale on the condition of the roads and the width and the parking. In addition to that, if there was an HOA, I'd talk to the HOA, and usually the HOA, if they had an HOA that outlawed in their areas any kind of VHRs, then it was do not pass go. We just don't do anything in that neighborhood for rentals. There was some other questions that we answered on our handheld app that related to how you can access the neighborhood off of Highway 50. If you ever try to go down 50 with cars on your tail at 40 miles an hour with black ice trying to make a right-hand turn with no lane, that's not a high grade. So we lower the grade on those exits from the freeway. As well as if you're coming onto Highway 50 from the neighborhoods, there's a lot of bends on Highway 50. So, you have to gun it to get out to the road. I had to do it with my super fast rental car or a county car. And so it wasn't fun trying to go do that with those 4-cylinder cars. So, you know, there was just a lot of those type of things. And then, you know, ideally looking at just the density of the neighborhood. Are the houses close together? A lot of them in Zephyr Cove over out the Lincoln Highway are very close together. Lincoln Park, they're right next to each other. There's barely any parking. There's barely any driveway parking. In an emergency, you can't get out of there. Why would you make them 15%, right? And so those were some of the questions I was trying to answer. So while you may agree or disagree with the results, you know, that's what I came up with. So the neighborhoods are not static. They're not 15 or 20%. They're based on what I thought the neighborhood should be. So that's how I did it.
I appreciate that. And then
Thanks.
just my final point, and then we move on, is this guiding principle says that the chapter should resemble the existing residential uses. The existing residential uses vary by neighborhood. I think we need to have permits vary by neighborhood, as already been stated.
Thank you. We ready to move to the next item, the 100-foot rule?
It is. So Ernie Strela for the record. So currently, there's really nothing in the code that talks to any tier in distance apart from each other. I know in the tier 3 meetings, we have buyer's rule, or we have, you know, some unique rule sets that each individual advisory board member utilizes, and that is important to them to make sure that we cover and that we understand for a tier 3. And I think that that's been pretty successful. And I think that what the advisory board decided to do was to administer a more formal approach for a tier 3 and a tier 2 10 occupancy with a 100-foot distance rule, property line to property line. So basically, I think for the current tier 3s, that would, it's already kind of being done right now. I think it would be more effective for the up to 10 occupancy tier 2s, where there is nothing written right now. So depending on the neighborhood, that would, you know, I think there's 75 or so tier 10 occupancy tier 2s right now. So that would be the effect, right? There would be a nominal effect on the density there. And it's also, you know, when you have 10 people can make just as much noise as 12 people, you know, and if you have extra people show up, you know, as the code is currently written, it allows for some level of distance between properties.
So, Mr. Strelo, it says current tier 3 VHRs must be located sufficiently far away from neighbors so as not to create a nuisance. That's the current code. Who determines that sufficiently far away enough from neighbors so as not to create a nuisance? Who physically does that? Who?
Is that a tier 3 question or just in general?
Well, no, it's a specific question. Who makes that determination?
The advisory board makes that decision.
They make
For
that.
tier 3.
So they make that decision when that tier 3 is applied for and comes before them for approval.
Yeah.
They currently make that decision. What
Yes.
they're looking for is a definitive rule of 100 feet.
Right.
Okay, so, but I know that you know, and they had to come up with some number, I suppose, okay? But is 100 feet sufficient enough? In some cases, probably not. And in some cases, 75 feet or 50 feet might be sufficient. So I'm not sure we necessarily need to tweak this. I don't know. Commissioners, that's just an observation I'm making here. I think Commissioner Noasad had his light on, so go ahead, Mr. Noasad.
I think, not to use the words used by lawyers, but it's capricious. It could be 200 feet, it could be 500 feet, but depending on the situation, how many people you got, and if, I mean, you said that 2 people could do much harm is 10 people. You haven't met my sister-in-law. Anyway, I think whatever we decide on here, I think 100 feet is not enough.
My question is, we had discussed this, what do the other jurisdictions do? In Las Vegas or Clark County, the county does, they have a distance requirement, I can't remember what it is, but you had mentioned El Dorado County, what is theirs?
Yeah, Ernie Strelo for the record. Yeah, El Dorado County, not South Lake Tahoe, but the county itself has I think it's a 500-foot limit. There's one of the, I thought it was North Las Vegas, maybe it is Las Vegas, but one of them had, they had a 300-foot limit. There is no other limits. Placer County, which currently has the most VHRs at 3,900 in their cap, they have no limit.
So I think if we're talking about problems with VHRs in the neighborhood, it's the close proximity to one another. And the person from Tahoe Beach Club had spoken how there's 7 VHRs in his one building, but and it falls within the percentage because all the buildings, there's 3 of them there now. Yeah. So I think this is one of the most important ones. I think 100 feet is too short, and most importantly, I don't see why it would be limited to tier 3 and 4, which I know there's no 4 now, but why limit it and not include all of tier 2, and especially multifamily? Because I think right now you're only talking about single-family homes. It's worse for a multifamily place to have multiple VHRs in the same building. They're all on top of each other, making this huge ruckus. So I would like to see it closer to the 500-foot. I'd like to see it applied to all tiers 2 and 3, and that it definitely applies to both single-family residential and multifamily.
Question. You said the distance of 100 feet is measured property line to property line? Don't the property lines abut?
No, it is Ernie Strelo for the record.
Or you mean from house to house?
House to house, yeah. So, it could be if there's a house on a court and there's a house with a VHR and a house a couple houses away wants to become a VHR, if they're within the 100 foot rule, they wouldn't be eligible to apply.
So let me make an observation based on what Commissioner Tarkanian just said. We just approved a 40% density in Tahoe Village. But this only applies to tier 3s. But if we change it to apply to tier 2s, then that 40% isn't going to do anything. I mean, it's not, there's, you can go to 20 VHR. Yes, please, correct me what I'm saying.
Ernie Strelo for the record. Yeah, the red line actually cuts out Tahoe Village from that restriction.
Okay, even in tier 3s?
All tiers.
All tiers, okay. So that was,
It's because the advisory board, I think all of them and yourself concluded that was a extreme tourist destination. How about that, instead of just tourist destination?
Mr. Rice?
In El Dorado County and Clark County, in other places, dirt is not as expensive as it is in Lake Tahoe. We don't have a whole lot of dirt for sale here. And a lot of places, 100 feet between neighbors is not possible. I like the fact that the board, up till now, it's been sufficiently far and determined by each case. I don't like shotgun approaches to anything. You wound people that are victims and not suspects. I don't think that here at the lake 100 feet is reasonable, and I like the sufficiently far to be determined. And granted, that gives attorneys extra money in their bank, but I think that making it a solid 100 feet period is excessive. So I like the sufficiently far.
Commissioner Hales, you want to weigh in on this?
or Mr. Strela had
I just wanted to clarify. So the code that is sufficiently far is only for tier 3s right now. So the 100-foot rule is for tier 3s. That's how the code is, the red line is, right? So if you want to add, so I will add that tier 3s that have been approved, the advisory board has, I mean, some cases it's a quarter mile. I mean, it's they make big distance requirements. So 100 foot is pretty low compared to what they had been doing.
I think that sufficiently far is a far more reasonable measure. And that gives you and your crew discretion. I'm not sure how the attorney feels about that. I don't see that as being arbitrary or crossing the legal lines here.
This is AJ Hames for the record. I don't have a concern, but I did just want to clarify because I think based on the discussion, there's a little bit of confusion as to what we're all talking about. So there was reference made, first of all, to other jurisdictions, why we're kind of working with a smaller number. And then just to provide some background as to how we got to this rule, this has been a rule that the advisory board has been sort of applying unofficially. They've been using it as sort of a rebuttable presumption. They ask, you know, they look to see how far away the tier 3 is from the nearest residence, and if it's 100 feet, they sort of assume that that's sufficiently far, but then they ask questions to confirm that. If it's less than 100 feet, they assume it's not sufficiently far, and then again, they ask further questions to make that determination. But it's already been adopted unofficially by the board as sort of a guiding tool, and what they're proposing here is that it not be just sort of this rebuttable presumption tool that they use, but a hard and fast rule. Just 100 feet, period. Every tier 3 has to be 100 feet from any, not just the VHR, but any residence. The only exception was for Tahoe Village, just given the nature of that community. But it would be a hard and fast rule applicable just to the tier 3s. And they had proposed tier 2s with 10 occupancy as well.
I don't have a hard feeling on this. I mean, so Commissioner Hales, what?
I like the rebuttable presumption part. That way, if you have a weird thing like 2 garages and the living areas on the far sides, on both sides, there's wiggle room to allow 95 feet, for instance. Who knows if that would ever happen, but I prefer the rebuttable presumption than a hard and fast rule.
So
perhaps that could be worded in a way that says, from the farthest point to the farthest point on the adjacent houses.
So Commissioner Hales, you're in favor of leaving it the way it is now and leaving it up to the VHR board when they appear,
Except if they wanted to write in there, there always a rebuttable presumption of that 100 feet is necessary, is the appropriate amount or whatever. I'm okay with that.
Commissioner Tarkanian, you want to weigh back in?
I don't think we should have VHRs next to each other, so I'm talking more like El Dorado County, and I think it should be a 500-foot from one VHR to the next. I thought that's what this was about. I misread it. Thank you for the clarification. I don't think this does anything. It certainly isn't going to protect the vast majority of VHRs out there.
And Commissioner Rice, you're in favor of staying with the current language?
Yes, sir. I think the current language is sufficient.
Okay, so I don't know that we have a consensus here, do we? I mean, you're all for the 100 feet. Commissioner Hales, you're all, where are you at? You're not for the 100 feet?
I lean more to the current.
Current. Okay. And Mr. Tarkanian wants even more stringency on it, right? And Mr. Rice is in favor of leaving it as it is. So I think we should just, I would concur on that side, is just let's leave it as it is and let the VHR board make their determination.
Commissioner, if I may. Maureen Casey, speaking as the chair of the Planning Commission, if I could just put 2 cents in as to the discussion at the Planning Commission. We didn't talk at length about this item, but it was brought forward that the director did go out to properties and took into consideration the terrain surrounding VHRs when they were getting permitted, when he did inspect the properties for the suitability for a permit and whether or not they needed noise monitors and other things. And we felt that it was not something we wanted to determine whether or not setting a limit as to 100 feet or whether it was sufficiently far away, whether the language was something we wanted to weigh in on, because leaving it to the discretion of the director was more appropriate. And then he would make the recommendation to the VHR board, if that clarifies something to you. I didn't want it to fly by and have you think the Planning Commission didn't think this was important enough to weigh in on. Thank you.
No, and I appreciate that. And I think we have to recognize that the Planning Commission had very, very little time to really focus on this. You know, I mean, the VHR Advisory Board spent months on this, and you folks only had a few hours, and we're trying to go through this ourselves in less than a day, right? So, but at least we have some good things here. So I appreciate that input. Okay, so basically no change. I think we have a consensus of no changes to the current, but we need to review it again, maybe, perhaps at some point in time down the road.
Okay, Ernie Strela for the record. Now we're here at noise monitors. So right now, similar to the previous slide, noise monitors would now be required for 10 occupancy on up on tier 3 and 4, or tier 2 and 3, I guess, at 10 occupancy. In addition, the county would impose noise monitors on lower occupancy units if substantiated noise complaints occur at least one time. In addition, the code would be revised to ensure county access upon request for noise monitor information. We also changed the CEL level from the average sound over a period of time to decibels, and length of time are also added. So so it's on your slide up there. So the noise monitor is required for tier 3. It would keep it that way, and it would add it for the 10 occupancy on up. Noise monitors are currently may be required for 2 on 2 credible noise complaints. That changes to 1 credible noise complaint, substantiated. And then for features, you know, this is more of us getting access to it. The code doesn't identify the county ability to access the noise monitor information. And so this will be changed and updated in the new code if you approve it.
Okay. Noise monitors is one area that concerned me greatly as we went into this thing. So I mean, we're not going into the tier 3 or tier 4 process. So currently we only require noise monitors on tier 3 unless it's determined, I believe, by yourself of whether or not that level 2 may, after 1 substantiated noise complaint, then you go ahead and you have the ability to impose noise monitors yourself. Am I correct in that process?
That's correct.
Okay. Now, this gets to the area that I'm afraid that we may have overlooked sometimes in our code in the point of first contact process. Okay? Because it's my understanding that when we had a noise complaint, the first point of contact was supposed to be to the homeowner or the property manager before we called code enforcement or the sheriff's department. I thought that was the process. Have we sidetracked that, or we have not used that process? What are we doing there?
Ernie Strela for the record. So if somebody has wants to call in a noise complaint to code enforcement, what they'll do is they'll call the hotline and they'll get a call from host compliance, or they'll talk to host compliance, a live operator, and the live operator will give the caller the contact information of the emergency contact. If that fails, the host compliance operator calls back within a half an hour to an hour and lets them know, it tries to see if it got resolved. If it didn't get resolved, they're instructed to call 911 or the non-emergency line. It depends on the circumstance. If it's an emergency, call 911. If it's not, they should have done that anyways in the first place. But they would call the sheriff hotline, and the sheriff would dispatch somebody out there to go up and do a knock and talk at the door.
So if a noise monitor goes off in a VHR that currently has one, who is identified through that noise monitor?
The property manager is the one that's managing the noise monitor. If the noise monitor, if it's middle of the night and the noise monitor is going off, what they're supposed to do is the property manager is supposed to get with their own emergency contact and figure out what's going on in the house. And if they're not doing that, then what I just described earlier was what they should do. It's what a neighbor will do.
How are we verifying the validity of the property manager or the homeowner? How are we identifying the validity of it? And I only ask you, okay, so I'll give you have a question on your face, so I'll give you a perfect example. I got a call from a resident that indicated that there was tremendous noise over the last 3 days on their property. And so I didn't know who to contact. I said I'd look into it. So I happened to reach out to Ms. Romaine on that, and she gave me the name of the contact. I called the contact and only found out that that contact was in fact the maid who's going to answer noise complaints at 1 o'clock in the morning. Okay, so that was an invalid contact number to eliminate and mitigate that problem. So that's why I'm asking the question: how do we go about validating that that contact is in fact the person that should be contacted to shut that activity down?
So you're asking me several questions, so I'll try to address them. So as far as the validity of emergency contacts, we do spot audits now of the emergency contact because the code requires that the homeowner or the property manager to have a correct emergency contact on file with us. And so if we call and if we talk to a maid that is not supposed to be an emergency contact and we come across those, we can institute fines on the address and on the homeowner. So that's one way to correct it. And then your other questions about, if there's a noise, if there's 3 nights of noise, and you're calling the emergency contact, I assume you're calling them more than once, and you're getting the maid, then you should be calling the sheriff to come out there and do a police report on it, because that's how we substantiate the noise.
So I know that Ms. Dingler's issue here is with noise, or is indicated that it's with noise. And, her blanket answer to me when I ask, are you calling code enforcement? Are you calling the first contact? I get the answer, and correct me if I'm wrong, Ms. Dingler, but I get the answer, they don't care and they don't respond. So that, obviously that concerns me if we have a noise problem there.
Ernie Strelo, for the record, Ms. Dangler calls the sheriff to her house to talk about the noise complaints of 650 Tina Court or 206 South Benjamin. And the sheriff routinely takes notes in the police report that we do have a lot of that indicates that Ms. Dangler, there was no noise complaint, and the only noise I can hear is the ESPN game going on down the street. In addition to that, Ms. Dangler has been on the record with the Sheriff's Department that indicates that she's merely trying to shut down VHRs. That is the purpose of her phone calls.
Okay, I don't want to get into a he said, she said.
I'm just saying I have the police reports on that,
okay.
so you brought it up.
Okay, I did, I opened that door.
Yep.
So, okay, I think I've asked enough questions here. Commissioner Noasad, you had?
Yes, in my previous life, I was an instructor. And I said, there is no such thing as a dumb question except the one that isn't asked, so I'm going to ask. Is the noise monitor on all the time? Is there an on-off switch?
It's supposed to be on all times.
Is there an on-off switch?
There, a lot of the remote ones are battery operated. And what I've noticed that with the batteries, when I go out to some of these houses, is that I've asked for a homeowner to prove to me that the monitor is working, and in some cases it doesn't, or it's not picking up the noise. They have the base station inside the house that plugs in, and then it emits the Wi-Fi signal to pick up the remote ones out in the yard, because they're not wired. And so they have NiCad or regular batteries, and they do wear out. You know, the weather up here corrodes the batteries fairly quickly.
In Hawaii, we call it a puka, a hole.
Commissioner Tarkanian, anything you wish to ask about this?
No, I just, I stated this earlier, I think we should have noise monitors for all Tier 2 along with Tier 3.
Commissioner Hales?
I don't think we need them for all. When there's a problem, they should be required.
Commissioner Rice, you want
to? Thank you, sir. I'm good with the way it is, with the, I like with the good morning. What the VHR board suggested, that noise monitors may be required in any VHR with one substantiated noise complaint. I like that addition, and I like the substantiated part. So level 3 should have them at all times. Level 2 or level 1, for that matter. If there's substantiated complaints, then I believe that they should be required.
So he's suggesting a hybrid there, okay? So we stay with noise monitors on all Tier 3s, and we require noise monitors on Tier 2 with one substantiated noise complaint versus the 2 credible noise complaints that are currently in there. Everybody good with that? Oh, I mean, Danny wanted, Commissioner Tarkanian wanted all noise monitors on all Tier 2s. And I tended to be in that feeling as well when we entered this. But I tend to go with the one complaint, then yeah, okay, let's do that.
One other thing, no requirements for noise monitor features, and then under the VHR Advisory Board, added requirements for noise monitor features. What are those requirements?
This is AJ Hames from the DA's office for the record. I'll direct your attention to, let's see, 040D of the code, and I'll give you a page number in a second here.
Okay, and I would note that on Tier 1s, we have built-in noise monitors, right?
Okay.
The residents.
It's page 69 in your packet. If you look at page 69 in your packet, you'll see the requirements. There's essentially 4 requirements in addition to some clarification on where they should be placed. The first requirement is that they monitor both volume level and duration of noise. The second, a log or record of noise data that can be maintained for a period of at least 18 months. So it has to keep track of noise events. Third, a notification system that alerts the local contact when noise levels exceed 65 decibels continuously for 5 minutes, and when noise levels exceed 85 decibels regardless of duration. Those decibel numbers are adapted from this, what are those called? It's the TRPA limits, but they're not decibel limits. They're decibel, CEL, thank you, which is, it's essentially a decibel limit measured over time. And so in keeping with those, 65 CEL is typically used in most TRPA plan areas. And so that's why the board was recommending a 65 decibel continuously for 5 minutes, and then a large, a more loud event, 85 decibels, that would cause an alert regardless of duration. And then the fourth requirement is the ability to share that noise with Douglas County. And then you'll see also in D that they're required to make that available. Let's see.
Okay.
And all this if the batteries are good.
Well, if the batteries are dead, that would be a violation of the section because it wouldn't be doing these things.
Is it up to the owner to keep the batteries up? Or
They would have to.
Okay, so we know where our direction is on noise monitors, right? Got consensus there? Okay. Okay. The next one then is owner and waiting period for permit, right?
This code would impose a 12-month wait period for new property owners. It requires that owners be more established in the community before they attempt to make money from it. The idea was that a year of ownership would help them understand some of the unique challenges of owning a home at Tahoe. The intent of this rule was to ensure properties were not purchased for the sole purpose of monetizing them as VHRs, sort of acts as a cool-down rule. This update also recognizes the housing shortages in Tahoe and is meant to slow down immediate conversion from full-time use to VHR use upon purchase. The Planning Commission did not disagree with this provision and determined that a person should not have to wait to apply for a VHR permit. I'm sorry, did disagree. Did I say did? The second issue is merely codifying that a person or persons, that's the bottom boxes, converting personal ownership to an ownership by trust or LLC is not a change of ownership. This has been county policy, but it's not currently stated in the code.
A question on that one. Is it, when they transfer to the trust of the LLC, it's got to be 100% transfer, meaning to that person, or can it be to different family members and so forth?
Yeah, same person. Yep.
So I have a legal question here, and that's whether or not this is it legally, can we legally restrain a person from using their property in this manner once they purchase it for a year?
Can I piggyback a question on that?
Sure.
My question was, what evidence do we have that this is currently a problem?
Sorry, can you repeat the question?
What evidence do we have that it's currently a problem for, are people coming in and just purchasing to, be, I can't remember how you described it, just to own it and make a bunch of money, monetize. And what evidence do we have that that's happening, or what evidence do we have that a property owner doesn't understand the unique challenges of owning a home in Tahoe in less than 12 months?
This is Ernie Strela for the record. I think that there's a perception that that is happening currently. That's all the evidence that I currently have.
Apparently our assistant county manager has something to add to that.
Thank you, Mr. Chairman, members of the Commission. Jennifer Davidson, Assistant County Manager for the record. At the time the VHR task force was assembled, staff did gather information that we felt was relevant on any studies that had been done on VHRs at Lake Tahoe. Included in the information that we provided to the VHR task force was a Mountain Housing Alliance white paper, which I'd be happy to provide the County Commission with a copy, and also can make it a part of this record if it's your desire to see that be included. In that Mountain Housing report, it specifically makes a number of findings, and if I'm recalling it correctly, states that one of the findings is that VHRs do have an impact on the affordability and availability of housing in Lake Tahoe. There's a number of recommendations tied to that finding, including a suggestion of a cooling off period. As I mentioned, I'd be happy to share that information with the commission.
Thank you. Any questions? No?
The follow-up is, what's the legal analysis on this?
This is AJ Hames from the DA's office for the record. It's not unlike any other use restriction with regard to property. Anytime you restrict use, you have to have a basis for it, a rational basis. And in this case, the basis is in one part that we're trying to decrease the conversion of full-time residences to VHRs. One way to do that is through the cooling down period. Another basis was alerting people to the unique circumstances of owning a property. I think as we were conducting Tier 3 hearings throughout the past year, it became evident during those hearings that the owners who are best equipped to comply with the code and to ensure that their renters were using a property consistent with full-time residents, those owners were those who typically had owned the property for longer periods of time. What we saw was that people would come in, they would buy a home, and immediately start using it as a VHR, often managing it from far away, not fully understanding and recognizing some of the challenges of snow removal, for instance, or how sound travels through the canyons and tends to bounce off granite and things of that nature. And so the cooling period also was intended to ensure that when people buy a property in a neighborhood, they're not buying it for the sole purpose of then utilizing it as a way of making money through VHRs, but they are going to take time to either occupy it themselves, rent it out to somebody else on a more full-time basis, but whatever they do with it, it's giving them an opportunity to learn more about the area. So those are I think the two main areas, the two reasons and rationales for adopting this waiting period.
Okay. So I have to ask a question in regards to the waiting list and how long an individual may be on a waiting list in the lottery system, and then how long does it take them to be approved for a VHR? If they bought that property today, how soon can they get on the waiting list, and when do you open those up, and then what's the time period for them to be awarded a VHR permit if it's like a Tier 2?
Ernie Strelo for the record. So current practice is we have a wait list application period from July 1st to July 31st of each year. And then we take we close the application process, and then we send it out to a randomizer. Basically, it moves it around and comes up with a different number. And then we come back and we just kind of plan out the invite. We meet every Monday right now, or we were until we're actually done for this year on releasing. But we started in December releasing this last time, so it would have been a 6-month from the application already, from when we started doing the release, and we were doing about 5 to 10 a week. And we just finished the release of non-constrained neighborhoods of 54 people that were on the wait list. So there's about 30 still on the technical wait list. That means that the neighborhoods are full, and so we can't release any properties to that. Now, this year, we're looking to do away with the wait list for non-constrained neighborhoods. So it would be more first in, first out, more of a FIFO process. We haven't seen a big, nowadays, I think it was to slow it down previously, but right now we don't have a purpose for the wait list, except for the constrained neighborhoods. So in the future, it would be, they can apply today and get a permit, however long it takes to go through the process of uploading all their information and getting the property checked. Few weeks, month.
Okay, but we say here the individuals must hold title to the property for 12 months before applying for a vacation home rental permit. So the process could be 1 year, they buy the property, they have to wait a year before they can actually apply
in the
for
new
that
code.
permit.
Yes,
On
yes.
the new code, if we apply. And in that process, then they're on the waiting list, okay? And so
that may take another year to get through that waiting list?
Let's be clear, there's no wait list after this year except for constrained neighborhoods. So if there's a 12-month, if you choose to add a 12-month wait list, or wait period for after you buy a piece of property with a house on it and you want to rent it out for a tier 2, you have to wait 12 months after you purchase the property, right? Because that's what the code says now. And then after that, there is no wait list beyond that. They can apply for a tier 1, 2, or 3 and go through that process if it's an open neighborhood immediately.
Okay, and are we talking in this particular area, are we talking about the, there's been a concern also that I felt is that when somebody applies for a tier 3, they're able to operate as a tier 3 until such time as the VHR board hears that. Is that in this particular area, or is it in another particular area where we're trying to define that down further?
Ernie Strelo for the record. So there is a new provision that has been added to the code to eliminate provisional permits for 180 days pending VHR board approval. That's what you're talking about, I think. And there's also another provision that we added, the VHR advisory board added, that before they can go from a tier 2 to a tier 3 in the first place, there's a 12-month waiting period to make sure that they're operating as a good host.
Okay. Okay. Commissioners, Commissioner Nosat?
Yeah, it's something that the attorney said that kind of piqued my interest about letting people or asking people to live in the place for a year before they make a decision about VHRs. Now, that tells me that those people are coming in with the intent of turning that property into a VHR. That is commerce, in my estimation. So I don't know that either of these cases is going to be the right thing to do. I don't think it's the right thing to do, to say, yeah, come on in. We'll give you 12 months to figure out if you like the place or not, and then you can get a VHR or not get a VHR.
Commissioner Tarkanian?
I'm all in favor of both. Again, I'm just all over the VHR Advisory Board's recommendations.
Commissioner Hales, any other comments? No? Or Commissioner Rice?
Yes, I'm a little concerned about the 12-month wait. I'll give my next door neighbors as an example. Nice young couple, fresh out of college, got their first job as an engineer. Thanks to the modern electronic age, they're able to work from home. They bought this house knowing that it was going to cost them $1 million or so, and they didn't have $1 million or so. But they bought it and converted part of the house into a Tier 2 VHR so that they could afford to live at Lake Tahoe. And I know of several cases where people, if they had to wait for a year, they would not be able to live at Lake Tahoe. I'm concerned about the year wait. I think that a shorter period of time would keep most speculators from buying property here. But I don't want to penalize young people trying to make the move to Lake Tahoe, because I know I personally could not afford to buy my own house. We've lived there for 30 years, but it has gone ballistic. My neighbors' houses have sold for over $1 million, and I know for sure that my wife and I couldn't afford to buy $1 million. Well, we can now because we have a trade-in, but we would have never been able to move here. And this is a wonderful place for people to move and raise their children. And I'm sure that our school district would love to have more kids because they're in the process of ebbing, shall we say. So I think 12 months is too long. I think that 6 months would be sufficient, and I would like to see us go with 6 months.
You're splitting the baby there.
Yes, I am. All over the floor.
I don't think that 6 months is necessarily an undue burden, you know, but I'm wondering if a year might be too long. I don't know. I'm kind of split on this. I really don't have a real hard feeling on this. Commissioner Hales, what I need some input here from you.
I was hoping to get really good evidence that we have a lot of people monetizing. I didn't hear it. I do have concerns about affordability and availability. So this is it's probably because it's 4 o'clock and it's hot in here. It's hard to make a decision on this. You know, six months is a kind of a weird, you can't get a long-term rental. I mean, maybe you can for 6 months. I don't know, that's weird. I mean, if people have to wait 6 months, they might just wait a year. You probably get a long-term rental for 1 year. I mean, this one, I see compelling arguments on both sides, but since I didn't hear much about monetizing, that concerns me. I don't think it takes a full year to understand home ownership in Tahoe. Maybe it does. With snows like this, you can talk about it, but it's different when you live in it. I don't know. Any other wisdom down there? Maybe we say one winner.
Well,
That would find out if they're really into this thing, right? Yeah. So, Commissioner Noah said you had more to
I learned something a long
add.
time ago about affordable housing. It's what you can afford. And if you can't afford to buy that house in Lake Tahoe, then don't be trying to buy it because you might make money in a business made of that house. So I'm for eliminating this entire thing about a waiting period or anything like that.
So you're in favor of no waiting period? Okay.
That is correct.
Okay. Okay, then I think we do have some sort of consensus here, because Ms. Hales is good with just no waiting period, right? Is that what you indicated?
I've indicated I'm torn, and I hope you guys would just make the decision.
and I'm sitting down here hoping that you guys do. Okay, so just leave it the way it is, but only add that section.
We can change it later. I mean, I hate to kick the can down the road, but I do understand property rights. People have property rights, and there are people who are able to make a go of it with VHRs and legitimately want to have a home here. And I don't know.
Okay, so the feeling is.
Wait a minute, let's
So
not
the
talk
feeling
about property
is.
rights.
I'm sorry.
When I said get rid of it, I'm saying, I'm looking at the current column. Get rid of it. Dash it.
Okay. Okay. So, so I guess I'm going to fall on that. I guess that's really what it comes down to, because I think Commissioner Tarkanian says 1 year is fine, and Commissioner Noah says 1 year is fine also. Am I gathering your thoughts correct? Oh, okay.
Let me reiterate, maybe I should say it in Polish. Individuals may apply for VHR permits regardless of how long they held the title of the property. Delete that line. Silence on the issue of self-transfer of title. Delete that line. In the current.
Okay, and so you're accepting the VHR Advisory Board's new suggestions? that there be a 1-year waiting period, and the individual may transfer his or her title trust to an LLC and retain their permit, right? You're good with that? Okay, and Commissioner Tarkanian is of the same ilk?
I'm sorry, this is going way over my head. It's
Yeah,
back and forth.
you're in concurrence with the advisory board's recommendation on that particular item?
Yes.
Okay, Commissioner Hales is not. She's good with current. Les Rice is current. I'm still having trouble here, Mr. Noaceto, understanding exactly where you are on this.
What does the current code say about that very thing? Yeah, I know, and that's what I want to get rid of. There's no need for any waiting period. If you want to buy, if you're going to want to buy a house and want to start a VHR, fine, do it. I don't recommend it, but do it.
Okay.
There currently is no waiting period.
But what about what's the verbiage? Individuals may apply for VHR permits regardless of how long they have held title of the property. Why even mention that in the code?
Okay. Okay, I think we know where we are here. So we're going to stay with the current indications of the VHR permits regardless of how long. However, we are going to adopt an individual may transfer title to his or own trust LLC and retain their permit. Is that where we are?
That's where you are.
Commissioner Hales, you good with that?
I think it's you and me that have to decide this. I could live with that. I could live with that.
And review it at a later date?
Mm-hmm.
Yeah, okay. And Mr. Tarkanian wants to go along with the Vacation Home Advisory Board recommendations.
I want to show my respect and understanding and appreciation to the advisory board, yes.
Okay. I think we're there. I think we know where we're going to go. So we keep the current first paragraph, but then we go to the second on the advisory board and we add that language in, right? An individual, okay. Mr. Hames, you got that? Okay. Okay, next.
Next one is insurance. Now, this is going to be a little more difficult to read now because there's no tier 4, but I'll try to read this so it makes sense. So right now, there's $500,000 in general liability for tier 1 and tier 2 and $1 million for tier 3. That's simple. There's no restriction on umbrella policies currently, and there's no requirement that the county be named insured. So the proposal is to keep the $500,000 general liability for tier 1, and for tier 2s so for tier 2s would be $1 million from $500,000, and then tier 3 would be $2 million. And then the advisory board prohibited the use of umbrella policies. Still no requirement that the county be named insured. And the planning commission essentially looks like in 3 out of 4 cases or 2 out of 4 cases they agreed with the 500 and the million that is currently in place. There's no from a restriction on umbrella policies, they didn't have a consensus. And then for the named insured, they require the county be named insured.
Okay, can I start off on this one?
Sure.
Thank you. I've been
Please.
quiet. First of all, just to add the county as an insured, it doesn't cost any more money, so it protects the county. I would see no reason. I'm sorry, I got to go against you on that one. I think the county should be named as insured. It protects the county. It's county's regulations, and as our assistant district attorney told us in our 2-on-1, the county could have some potential liabilities. I'm not sure why you'd want to prohibit the use of an umbrella policies. They're an additional cost, and they're usually required by the lenders. Can you give me a reason why they want to, what the purpose of that one is?
This is AJ Hames from the DA's office. There were a number of issues trying to verify the coverage of certain umbrella policies. And so from a enforcement standpoint and administrative standpoint, it was very difficult to confirm whether or not somebody actually had $1 million of liability insurance that would apply to their property. Lots of times they would submit an umbrella policy that would list maybe $2 million of general liability, and they would submit that, and it would list the address. And then when we would try to verify that that address had that same limit, they weren't sure, they didn't know. We had to get in touch with their broker. They would send us policies. We were reviewing policies. Oftentimes then we would find that no, in fact, each property would be only limited to $500,000 of general liability.
Great answer, thank you.
So I'm kind of, I'm not a guy, you know, an insurance guy. I don't know this. So I can only rely on what input I get. And I can tell you at the Carson Valley Chamber of Commerce meeting last Wednesday morning with the current chairman of the board and the president-elect, both being insurance carriers, they indicated to me that $2 million was an excessive amount and that and cumbersome. So I can only rely on that input for my knowledge in this regard. I don't, and I guess when Commissioner Tarkanian asked it required the county be named insured, what I'd like to hear what legal counsel has to say about that process.
Yeah, I would say of all of the proposals, again, this is AJ Hames from the DA's office, from the advisory board, I think this one maybe had the least of a basis. The idea was to protect the county, and their thought was, well, we'll just increase the limits then. But beyond that, there wasn't a ton of discussion. There wasn't a lot of data that went into it, but I think the idea was good. I think the Planning Commission's proposal is more defensible. It has a better basis. I think it would be easier to justify. And so my recommendation as council would be to go with the Planning Commission's proposal.
Commissioner Noset.
Yes, in going with back to the very beginning of the tier structure, we established 1, 2, and 3. In the VHR advisory, we start out with tier 1 at $500,000. Then we go to you mentioned 2 there, but you didn't say anything about 3. But it sounded like 3 came up at 200,000 or 2 million. You know. And same thing with the Planning Commission. So resident host tier 1 and tier 2 VHRs are 500,000, and tier 3 would be 1 million. Is that correct? Because you mentioned tier 4 in each of these, and I scratched them out and put tier 3 in.
AJ Hames again for the record. So the references to tier 4 in the presentation you can ignore those. Just when you see tier 4, think tier 3, because the board has decided there's not going to be a tier 4. So tier 4 means tier 3 for purposes of this discussion.
In that case, I come down on the side of the Planning Commission.
Michelle?
I would say yes, require the county be named insured because doesn't cost anything. I am happy with the existing limits, as was the Planning Commission. On the use of umbrella policies, what you said has me concerned that it's taking more time than it should. So I could go either way on prohibiting use of umbrella policies.
Okay. Commissioner Tarkanian, so are we all good with what the Planning Commission has
Yes,
indicated?
except I would prohibit the use of the umbrella policies. There wasn't a consensus there on it, but I think the legal counsel gave a very good reason why.
Okay, so on the planning, so we want to go with the Planning Commission recommendations, but add no restriction on what the VHR advisory board said, prohibit use of umbrella policies. Is that what you're saying, or the other one, no restriction on umbrella policies?
To prohibit the use of umbrella policies is what the legal counsel has suggested, and it made sense to me.
Okay.
I don't usually agree with legal counsels.
Okay, so we're in concurrence there, I think, right? What the PC requirements, suggestions are? Okay. I think you have direction there.
One question, are we agreeing that we are not going to prohibit the use of umbrella policies?
Is that the case?
I don't know, how big a deal is it to not have an umbrella policy? I don't know.
Why would we not want them to have an umbrella policy? We have one, and I don't rent anything.
Because he just said that sometimes verifying that a property is actually covered under that policy is cumbersome.
Well, it seems to me that we're protecting the county, but we're not allowing the person owning the property to protect themselves. An umbrella policy protects you, not anybody else.
AJ Hames for the record. Just to clarify, they could still have an umbrella policy. I think the way the red line is written is that they can't use the umbrella policy to achieve the coverage limits for liability.
So if they want to have one to protect themselves, that's wonderful.
Yes.
But we're not requiring them to, we're not allowing them to use the umbrella policy to take care of the requirements.
Correct, and that was mainly because
okay, I can live with that.
Administratively, it was difficult to track, and oftentimes when we investigated it, we found that the limits weren't actually consistent with the code.
Okay. We're all good with that? We have two more items, I believe, right? Two more items. We have the local licensed property manager and the and advertising. Should we take a short break here? Yes. Okay. We'll return at 4:40. That gives us 12 minutes. 4:40. Thank you. We're getting there. You okay?
These seats suck.
You know something? I was going to talk to Melissa about that. These seats
and chambers are much better.
Yes. Yeah, you noticed.
We ready to bring this back into session? It's 4:40. No, we're not, we have no. So, yes, okay, thank you. It's 4:40, we're going back into session. The question was, do we have a hard time finished? The hard time is when we finish these next two items, and then we'll have public comment, and then we'll adjourn. So that's whatever time that takes, it takes. So at this time, I think we're back into, we're now into the section called local licensed property manager. Is that, am I right on the right page? Okay.
That's correct. Ernie Strelo for the record. This slide is meant to define the duty of a licensed property manager and codify how far away from rentals they can be. The recommended code changes would require a local property manager for 10 occupancy on up, not just tier 3 or 4 SUPs, and would require the property managers to be local, meaning that they reside and work within an hour of the VHR. An exemption applies for owners who are within an hour of the VHR themselves. The advisory board has witnessed during the many tier 3 special use permit hearings that having local property management tended to decrease the amount of complaints from neighbors, as local property managers can proactively address problems before they impact neighbors. VHRs with property managers who were not local tended to generate more neighborhood complaints. Having a local property manager seems to effectively address persistent issues regarding the exception that local residents seem more able to fulfill this role of being a property manager. Owners in the Bay Area or Texas, for example, tended to not feel or understand the energy of concerns of a problem VHR. So I'll pass it back to you.
Yeah, thank you. I'm looking at the advisory board's recommendations. Property managers must reside and work within 1 hour of VHR. Now, this would only, what levels does this apply? The current tier structure, tier 3? Or is it tier 2 as well?
10 occupancy on up.
Okay, 10 occupancy on up.
Regardless of tier.
Okay, so tier 2s that have an occupancy 5 bedrooms basically, or 10, then they would be required? Okay. Now, I know that we've had some issues in the past where we've had some owners who have been fined because they are not residing within an hour, and certainly, so they claimed that they, whenever they rented out their vacation home rental, they would come up and take a hotel room but we're saying their home residents must be within an hour of their vacation. So we're clarifying that and cleaning that up a little bit and further defining that. Is that correct?
That's correct.
Okay. And that's good. And it doesn't matter if they don't have to be Nevada residents. They can be California residents as long as they meet that 1 hour.
1 hour.
And what are we doing to verify that they actually do reside 1 hour away or less?
Ernie Strelo for the record. So we verify with the homeowner's address of where they live. We get information related to utility bills and whatever else to prove that they live where they live. Beyond that, that's all we have, right? Unless we hire a PI or some,
Okay. Well, I certainly, I think it's important that we do define the property manager's duties, and I like the idea that they have to reside and work within 1 hour. I like what the advisory board is recommending here. Commissioner Tarkanian, I know you've been in agreement with everything the advisory board has done today.
I am so much in agreement with them.
I suspected as such. So, Commissioner Hales, any disagreements with this?
I'm good with this.
Okay,
There might be the occasional owner who's done an excellent job. I personally would be fine if the director had some leeway on that, but by and large, I like this.
Commissioner Novosad, any?
No comment.
Commissioner Rice?
I like it.
I guess that gives you the direction you need, right? That was a 5-0 thing, supporting the Vacation Home Advisory Board recommendations.
Sound like a 4-0 with a no comment, but we'll take it.
I think he meant he didn't have anything against it, so I think it was a 5-0.
Okay. And so the last one of the red sheet that you saw at the beginning, unless you want to go through the other 9 after this. This is, so this is the last one of the priority ones, and I think this is pretty important. And so advertising and VRBO and Airbnb can be confusing. For instance, some rentals indicate 11 beds, but the occupancy limit on the permit may be for 8 people. This recommended code update requires occupancy limits to be on the headline of the ad. Also, no more can they title a quote-unquote dozen beds, but have a permit for 6 to 8 or 10 occupancy. This change makes occupancy limits easier to enforce. So we come across this a lot on the headlines in code enforcement where we're finding errors, right? Where it implies that somebody's trying to oversell their units without actually, they're saying, hey, the occupancy is this, but I have 12 beds. Well, I mean, so it's confusing and it's not appropriate advertising for this county. So the VHR board prudently thought this through and talked a lot about this one, and I tend to agree with this. This is a good approach.
This seems like a no-brainer to me, so I don't know why they took so long to do it, but or spent so much time on it. But anyways, yeah, no, it seems like a no. Truth in advertising, right? Basically. Okay, Commissioner Hales, any further thoughts?
In my pre-commission life, pre-commissioner life, I lived this. I'd read it through, and I'm like, okay, they're telling me they have X number of beds, but only occupancy of Y? What are they telling? Are they winking? Are they like, yeah, just bring for the beds, So, yeah, I'm in favor of this.
They're going to use a bed every other night.
Okay. Commissioner, are you going to go no comment this time also, or what? Okay. Commissioner Rice?
Thumbs up.
Yeah, I'm good too. I think that's good recommendation, and I think you're good on that. So with that presents what you had on there, right? And was there any of the other items? I don't want to shortchange us here. I know it's getting late, but I don't want to shortchange us. This is going to be the opportunity we have, and then a proposed complete new ordinance, revised ordinance will come to us in another month as a presentation-only item. We'll have an opportunity to take a look at that, and then after that, it'll another month before it comes to us as an action item. Okay, so anyways, Commissioner Tarkanian, did you have any?
No, Commissioner Hales.
Oh, it's Commissioner Hales.
The phrase "in good standing" later on in one of the changes, I would like it to have more specifics about it. Like, what does it mean, in good standing?
I'm sorry, what means?
So in one of the other 9, there's the phrase "in good standing." It'd be nice if there were some, maybe you define that in the definitions, or you say without a history of violations or whatever it should mean. It'd be nice if it had some meaning.
My favorite attorney tells me that he will fix it.
Damn, you're not my neighbor anymore, brother. Chairman Gardner, can I just make a couple of comments about the work of the advisory board and some of their comments in the meetings?
I think that we can't go beyond enough compliments to what they did, so yes,
It's not all
please.
compliments, but I'll do my best.
Okay, well.
First of all, I agreed with most of your recommendations. I was very impressed with the honesty and candor of the advisory board and its meetings. At the January 11th meeting, Patty Graff stated that there are people like Tarkanian. He came from Las Vegas. He doesn't know snow, he doesn't know roads, and he doesn't know the neighborhoods. Well, Ms. Graff is partly right. I am from Las Vegas, and I happen to got elected to this wonderful county. However, Ms. Graff is missing the bigger picture. Knowing snow, roads, and neighborhoods is not as important as knowing what it's like to live next to a VHR. I have experienced that. Mrs. Graff has not. I experienced firsthand the vulgarity, the drugs, the nudity, and the noise permeating through these VHRs. I saw the effect it had on my 5-year-old and twin 3-year-old girls. No family living in a residential neighborhood should have to experience this. Let's be honest, no one wants to live next to a VHR, especially if they have young children. I spoke at the STARS group, the casinos in South Tahoe, and they told me that all the casino owners were in favor of VHRs. I told them that's not true. There's one in Glenbrook that isn't. Well, the representative said to me, well, he's only against VHRs in his neighborhood, not the rest of Lake Tahoe. Well, that's the point. Everyone wants VHRs in someone else's neighborhood, not theirs. Now, that's including the advisory board. In another moment of honesty and candor, Keith Byers wrote, what we observed after Mr. Stralo's presentation was that because certain members of the advisory board were unhappy that their respective neighborhoods' density was not reduced as much as others in the Tahoe Township, there was an inability to obtain an agreement to adopt Mr. Stralo's findings and recommendations. When discussing density for single-family homes and multifamily homes, Laura Romaine stated, a multifamily permit holder, who is a multifamily permit holder, she stated all people who moved here deserve to have the peaceful enjoyment of their homes. I agree. A person living in a multifamily home is trying to work nights. She deserves the same protection as a single-family home. Agree completely. Wait a minute, though. I thought with our new enforcement and our code, everyone was going to enjoy the peaceful enjoyment of their homes, that we wouldn't have these problems with VHRs. Patty Graff, who also was a multifamily permit holder, stated, a person owning a townhouse or a condominium shouldn't be penalized by having a higher percentage of VHRs in other neighborhoods. She also stated, this is kind of the problem with VHRs. There's a new idiot every weekend. And this is her in your guys' meetings. So in a moment of candor and honesty, the permit holders on the advisory board admitted that the VHR code and its enforcement does not stop or even minimize the harmful impact of VHRs. The only thing that will minimize them is reducing the number or eliminating them. If reducing the number of VHRs protects the peaceful enjoyment of a home, then shouldn't all VHRs be eliminated in residential neighborhoods? Shouldn't this board ban all weekend idiots? Keith Byers stated, right now my neighborhood has 10 people walking on my neighbor has 10 people walking on her living room ceiling every single weekend. If you limit VHRs in one neighborhood, you are going to drive people out of these areas into others and make a terrible process intolerable. Now, you notice those words? He uses the word a terrible process, and he uses the word intolerable. The real question you, the public, should ask the board is allowing VHRs in these residential neighborhoods resemble the existing residential uses? Do the other residential homes in Mr. Byers' neighborhood have 10 people walking on the living room ceiling every weekend? If not, and you allow it, you are not following our code. Let's be honest about this. It's all about the money earned from VHRs, the increase in valuation of your homes, and the tax revenue generated from VHRs. We have a simple choice on the board. Is the money more important than protecting the quiet enjoyment of a homeowner? The legal rationale for allowing VHRs in Lake Tahoe and not the Carson Valley is that Lake Tahoe is a tourist destination where all VHRs are appropriate and Carson Valley is not. Well, following this rationale, I made a proposal to allow unlimited VHRs in neighborhoods that were intended for a large number of tourists, limit VHRs in areas where there were a smaller number of tourists were intended, as like near the public beaches, and ban VHRs in neighborhoods that never intended for tourists, gated communities like Glenbrook. Laura Romaine stated, and I'm not sure if she was alluding to my proposal or somebody else's, but she stated, I have seen proposals that justify fairness. I have to admit, it scares the bejesus out of me to leave this kind of serious decisions to those types of whimsical reasonings. Well, what is most fair is to ban VHRs in residential neighborhoods. It's fair to everybody. In attacking my proposal, the advisory board has acknowledged that the legal rationale for VHRs in Lake Tahoe is not true. It isn't because Lake Tahoe is a tourist destination. Laura Romaine stated everything is tourist. We live in a recreational neighborhood. The whole area is recreational. Carson City, the valley, it's all recreational. Patty Graff stated, I agree with Lauren. This is the whole area is recreational. And I agree. If you want to include anything that a tourist might visit, I would agree that it includes everything, including the Carson Valley and Lake Tahoe. Well, if that's the case, then we, the county, have no legal basis to ban VHRs in the Carson Valley. In fact, Laura Romaine, you brought that up in either a November or December meeting about the possibility of VHRs in the Carson Valley. Well, we don't have a legal basis to prevent them here, to prevent them in the Carson Valley if we're going to allow them in Lake Tahoe and allow them anywhere. In fact, the lady from the Realtors Group stated today that she was so disappointed that the Carson Valley can't have VHRs anymore, and she was bragging about being the last one that stayed there. So even the realtors want to bring these VHRs to the Carson Valley. I'd like to see how that's going to go over to the public in Carson Valley. All right, fine, I'm almost done. It's interesting, in the very same meeting, the advisory board adopted my proposal on tourist destinations when it didn't affect their neighborhoods. Laura Romaine stated, 85% of me believes that Lake Tahoe is a tourist area. Tahoe Village is a tourist area. Ernie Strelo stated, our thought is that Tahoe Village is a tourist area. The entire advisory board determined 40% was an appropriate. I believe my proposal is the fairest. It does not please everyone, but it is the fairest, and I'm going to have it placed on the agenda for a vote in the future. However, this issue is too impactful to the residents of Douglas County. This matter should be decided by the vote of the people, not the Board of County Commissioners that change every 2 years. I encourage someone to start an initiative, put it on the ballot, and let the public vote. Thank you.
Thank you. Is there any other additional comments by commissioners before we go to public comment? Seeing none, it will go to public comment. This is public comment. You're allowed 3 minutes. Same rules as before. We ask you to approach the podium, sign in, and state your name, and then we'll start your time after you state your name. Once again, you're not required to take 3 minutes. If you concur with the previous speaker, you can say ditto. So, thank you. Go ahead.
Hello, my name is Robert Keller. I live in Tahoe Village, and I agree that tourists do come to Tahoe Village, but it is no more of a tourist destination than anywhere else in all of Douglas County, and I don't think it should be treated any differently. To double the allowed VHRs in Tahoe Village while you're cutting back everywhere else seems insane to me. Right now, Tahoe Village has no way to increase our parking capacity because of the coverage, I assume all of you know about, and we have 1.6 parking spaces per unit in Tahoe Village. So when a VHR gets rented out and 6 cars show up, they're taking up parking for all of their neighbors. And it's hardly bearable the way it is right now with the number of VHRs we have. Please don't double it. I mean, just don't. You don't have, just please don't double it.
Thank you.
Hello, everyone. My name is Jaron Gunter. I came up here to something that bothered me I saw happen in this room earlier. And we're here to give public comment to 5 commissioners. And I saw something that was pretty peculiar to me. I saw a commissioner get up, walk out down there, tap someone on the shoulder, and go outside and start talking to that person. After about a few minutes, 5 minutes or so, they came back in. The particular person that they were talking to has ties to the Planning Commission. And then I watched them walk around this room and tap everyone that made a negative comment towards vacation rentals, tap them on the shoulder, and look to me, start recruiting. I don't know if that is ethical, moral, or should be done. And it was just very peculiar that happened, and it was allowed to happen, why people are making public comment that you're supposed to be listening to, not getting up and walking out. That's all.
Thank you.
Hi everyone, my name is Heidi Gunter. My husband and I own world-class property management. We are local property managers here. We live here full-time, all year round. We don't leave for the summer, we don't leave for the winter. I want to thank everybody for all of your time. We finally got this done. I've been at almost every VHR board meeting. I've watched a lot of the Board of County Commissioner meetings online. The neighborhood study, awesome idea. I would love that because not all neighborhoods are the same. And I don't think it should be a higher percentage up in the Tahoe Village. People live there full time. So just because there's timeshares up there and just because there's more condos doesn't mean that the full-time residents up there want more rentals in that area versus another part of the neighborhood. And not counting minors in the occupancy is an amazing idea. We've been managing properties for 11 plus years. I can't even tell you the amount of renters that have tried to rebook with us now that the occupancy is lowered and they can't come back with their families because the occupancy has been lowered. If you keep lowering the occupancy, then you're deterring our families to come to Tahoe. And those are the kind of renters that we want to visit here, not our party groups. So thank you for not counting minors in this. I'm looking forward to the new red line ordinance to come out so we can move forward and actually use this ordinance and start finding those people who are not managing their vacation rentals correctly, because they're the ones that are making it terrible for the rest of us doing it correctly and following the rules. Thank you.
Hello, my name is Kristen Kearns. I concur with everything that Heidi just said, especially about minors. Our particular property, under the current regulations, we have parking for 32 people. We don't want that. We don't, but we're on a big street with a cul-de-sac, and I get how so many places can't accommodate an emergency. And then that brings me to the thing that made me freak out, and that's the insurance. Requiring named as an additional insured. I have plenty of insurance, but I got dropped from my policy after the Caldor fire, and I had to scramble to get new insurance. I have $2 million of coverage for general liability, but creating an additional requirement on people with the high risk that we might have and what we've faced is disturbing. I would not want to call my insurance company and say, I have to add the county, Douglas County, to my insurance company and face a review or a rate increase or some barrier to having insurance. We actually landed here because we had a house burn down in another fire. And I'm an attorney. I deal with insurance defense. I deal with claims. And so I think a lot more study needs to go, and maybe the state insurance commissioner could make a requirement if that's what you guys are gonna do with requiring that. But I think a lot more analysis. Yes. So that's just the thing that made me start having a panic attack.
Thank you.
Y'all might remember, you may remember me, if I can get it out here.
I think I know your last name now.
Texas.
Dean.
Dean. Dorothy Dean. And I'm sorry,
Got it.
I took tons of notes while y'all were talking. And so this is a little disjointed. But first I wanted to say that I'm not against all VHRs. I do think they have their place. And I have utilized one in the past once. I think that any woman that wants to stay in a vacation rental is crazy because it's just another house to clean. Stay in a hotel where they come and clean after you every day, women, because you know they're doing all the working and cooking. It's no vacation. It's not a vacation for the wife. But I wanted to say that all the talk that I heard, a lot of the talk I heard here today was about accommodating these families coming into town. But nothing or very little about the families that are here and the families that are being displaced by an excessive amount of vacation rentals or the rising prices created by the vacation rental market. My son, and you know I am from Texas, though he was born at Barton, has this like innate thing where he wants to play football. Cannot play football at Whittle. I have to take him 5 days a week to South Tahoe, more during the football season, because they cannot make enough. They used to have a 6-man team when my daughter graduated from there. My daughter has the best looking letter jacket of all time. She was varsity everything. Why? Because Whittle doesn't have any students. She played every sport. When she came home and said, "Mom, I'm gonna play basketball," that was the first time she'd ever said the word basketball in her life. And at practice was the first time she ever touched one. And she was on varsity. So what I'm saying is you're displacing the families that really have a financial impact here. These people that come into town for vacation rentals, they go to Costco and load up. Are they going out to eat like a regular family was? A family of 4 buying their groceries here, taking their kids to school. Is much more beneficial from a community of full-time residents. Then the ecological impact of not having this tourist center down around the casinos. These people are running up and down Kingsbury all day and night, going here and there, going skiing, coming in from Glenbrook to go skiing and driving back out. It increases the traffic on our road, which has this ecological impact, all the exhaust, and the frustration of being on these packed roads. So please look at the bigger picture. Protect the lake, protect the families that can live here year-round, and please adopt all of what they've suggested. Oh, the last bastion of affordable housing in Tahoe is Tahoe Village, so you might want to rethink that 40%. That's the last place where service workers can rent.
Thank you. Additional public comment?
Thank you, Commissioners. It blows my mind how much time and been here doing.
Can you state your name, please, for the
Drew
record?
Murin, Douglas County resident. Thanks for having me here today. Just again, it's fascinating that we've just been beating this thing together for 2 years. But you know, what really kind of shook me today was you know, we have a lot of disjointedness in the country right now, and hate can really play a fact. And the fact that certain individuals that they want to get rid of something so bad, they'll go to whatever extent. And that really bothers me within our county because I live, work, and breathe in this county. And part of what Wes Wright said earlier, you know, I'm a young individual who works in this community that actually is able to live in this community because of a VHR that I manage very, very closely living in the community. And it's allowed me to live here. A lot of my friends have had to move away and do other things because they couldn't afford it. And I've had to be creative and find that way to do it. And, you know, I'm glad we're on this path to finally come into a resolution so I can continue to live here through that income and actually be a homeowner in Lake Tahoe, which is almost unfathomable for a lot of people my age these days. Also, the tourism industry, what a lot of people don't understand is that Lake Tahoe has a ski resort. It has a lake. A lot of the houses, like mine on Kingsbury Grade, were built for that community. They were built because there was no lodging when Heavenly at Boulder Lodge and Stagecoach were built. Those residences up there were built like that. They're multifamily use for that reason. And if you didn't like it when you moved here, you shouldn't have moved here, bottom line. I mean, that's exactly what I'm getting at, that it is what it is. It bothers me that people try to change it. Let's manage it and do it well. On another note, we're facing tourism struggles here in Lake Tahoe. I know a lot of these folks around here are retired, they don't care, but those of us who work here and rely on the tourism industry, I mean, annual occupancy within the whole city from 1990 was 82%. In 2020, it's 65% and going down. Gaming revenues were $564 million in 1990. In 2022, they're $361 million. So if you look at traffic counts in 2002 were 35,000 cars a day according to NDOT, and now in 2021, they're 25,000 cars a day. So tourism isn't going up, folks. It's kind of going down. You're going to see it. We just came off the worst March that we've seen in a long, long time, all across the board. You're going to see that data come out. So you know what? We need to start embracing our tourism industry, showing them appreciation, and also trying to educate them on what to, how to handle our area and be good stewards of our community. I'm all about that. But again, without them, none of us are here. Thank you for your time, and I look forward to seeing the revision.
Paul Bruno. I do have a couple of comments that I think might be helpful as you have your additional deliberations that come up. First is on insurance. Being an additional insured is really a no-brainer because it provides the protection to the county that is necessary to the extent that some renter may try to loop the county into a litigation. For example, a code violation that's not seen by an inspector, a permit is given anyway, and I know you'll catch them all, but just in case you don't, a personal injury is caused by that. Why not be an additional insured than have a plaintiff sue you plus someone else sue you? You can just use the defense and the indemnity provided by the insurance that made it possible. The second issue I want to call to your attention is the 12-month, which I was in favor of, hiatus before a permit can be applied. I think that the evidence supplied by Jennifer is helpful, but there was a second reason that provides a rational basis for a waiting period before you get a permit, and that will do away with monetizing properties. And that was a study that showed the declination. It was 3 years ago, I think, that when this process was starting, the declination in the students in schools versus the increase in VHRs that were appearing. And that's the kind of thing that is helpful to have that hiatus period and not monetize immediately a VHR and displace individuals that either live here or indeed might have children and contribute to the community in other ways. I'm always available for questions. I appreciate your efforts, and I will tell you, I think that these VHR restrictions and amendments help rather than hurt the conformity with the neighborhoods, which I think is really necessary so that people get used to the idea that there is a rental, a VHR, next to them or within proximity. You've got to make them so they don't stand out and are inconsistent with the neighborhood. Thanks so much for your time.
Ditto, Mr. Bruno. I'll say that. He's amazing. He gets it. Hard work. It is hard when you've lived and breathed it for a couple of years to just kind of sit and not hear all the discussions. More than happy to look at neighborhoods, relevant factors, different neighborhoods. Just didn't have time. But the 15% is really important. And one of the things that I didn't bring up earlier was the insurance thing. I wish that somebody would look at a little bit more while you're kind of in this period, because my HOA has just been given our property liability is going to be increasing. They said anywhere, like if it's 5,000, it can go to 20,000. Their second question is how many VHRs are in your neighborhood? If you can understand the liability, icy roads, whatever it is, someone slip and fall, that type of thing. And so between the fire problem and now VHRs, our residents are going to be paying more for insurance. So the less we have in our neighborhoods, actually it's helpful, so I appreciate that. The waiting period, people can rent out full-time during that waiting period. It doesn't stop you from being able to have some income and that type of thing for that. It just may not be a VHR income, but they can get an income. It can do that. And it does help, and hopefully you'll look at that white paper, because I remember that from the task force days. And then the other thing I would just say to think on is the 100-foot rule. When I was listening to the discussion, the importance of it kind of got dismissed. Basically, what it's saying is the more people you have in a home, the more distance you need between that home and another home. And so as you can see with our tier 3, we used that 100-foot rule. 2 of them were less than 100 feet, and both of them have had complaints. The rest of them have made an impact. So that's why we were saying add it to 10s, because 10s are a problem, and it has worked in the tier 3s, and so therefore it can work here too. And so what you're basically doing is you're just saying to them, you can only be an 8 occupancy if you live within 100 feet of someone else. And to me, and I guess the rest of our board, because we recommended it, it is just a reasonable thing. The more people you have, the more space you need between. And something in this ordinance for the residents, that 100-foot was kind of a real important point. So thank you very much, all. Appreciate it.
Ms. Romaine, I don't know that you identified yourself the second time, but
I'm Lauren
unless I miss
Romaine.
it.
Sorry. Thank you.
I'm Linda Dangler. And first I'd like to address what Mr. Strelo said about me. Do I want VHRs in my neighborhoods? I was the petition lady to try to get rid of them. I don't need a whole bunch of these things in my neighborhood where I can enjoy peaceful quiet, and I now can't. And as far as the intent, and the day that the report that he's talking about, Bernie Hittner, the neighbor of mine, came and filed the same complaint. So it wasn't me, it was 2 of us. But hey, we'll discount that, not a problem. So the thing is about the intent of this code. I can tell you that in my neighborhood, there were 2, 4, and 6 people living in houses. The majority of the houses were empty. They were people's second homes, so there was nobody. So I came from a super quiet, very peaceful neighborhood, and right now I have 4 tier 3s on the canyon I live on, so I get the projected noise, you know, that comes across the canyon at me. They sit on the deck with their 12 to 14 people. It sounds like you've just made it so they could have 28 if they're a 14. I'm not so sure, but when they're out there, I'm affected by that noise. And in those, there's like a 10, a 12, a 14, and a 10, and an 8. Those are the ones that don't meet the intent of the code based upon my experience in my life, in my neighborhood. So you're not meeting the intent of the code. Every one of these tier 3s doesn't qualify as meeting the intent of the code. If you went to every person and actually asked us what the intent of the code would mean, everybody would tell you, well, I used to have 2, 4, and 6. I got a woman responding to a request I put. She said it was 2, 2, 2, and 4. Now it's 8, 10, and 5, and 10, and 12, whatever. So, you know, the point is you don't begin to, and then you don't enforce the codes. Doesn't matter what we do, the codes don't get enforced. I take photos. I produce everything necessary so that a code broken can be looked at. And guess what? There's no code violations. The situation is, in this deal with the Kaplan place, is that they're still running a residential commercial business, and you guys have just approved them to continue to do so. And I turned in a code violation to these guys now. They won't look at the truth that he already had booked them and there were fees. You won't come up with that. Code enforcement will go, oh, but he gets to have it. How, you know, you can't be bothered to look at what's really going on and look at the truth that he's breaking the law and stop it. No, that won't happen. They'll not look at anything, and then they'll tell you what they come up with, and it won't do anything to help those of us who live in this environment. You don't care about us. I mean, for the most part, we're not cared about at all. Never have been.
Additional public comment?
Mr. Chairman, I do actually want to add public comment if it's okay.
Always enjoy hearing from you.
Thank you, Mr. Chairman, members of the Commission, Jennifer Davidson, Assistant County Manager, for the record. It was brought to my attention during the break by a member of the public that some of my comments could be taken out of context, so I do want to provide you guys with some additional information regarding the white paper that I referenced. I think it's really important that you have all of the available information to you when you're making an informed decision as part of this process. Things to consider when you're looking at that white paper: it was not commissioned by us as the county, it was commissioned by another agency that had a very particular agenda in mind when they commissioned this report. They were looking at affordable housing in their jurisdiction. Additionally, that report was commissioned in 2016, 2017, those findings were made. Some things have happened since then. Measure T did have an impact on South Lake, and certainly South Lake has had some unintended consequences that they have observed with the abolition of VHRs in their jurisdiction. Certainly, if we had representatives from South Lake up here, they would likely tell you that houses have not become more affordable without VHRs. Nor have they become more available on that side of the lake. So important information for you to have. I thought you should be aware of that. My only purpose of bringing up that white paper was to remind the board of the information that was provided to the task force as they were making their recommendations. Any questions or concerns? Thank you.
Thank you.
Mr. Chairman, I got a public comment. It'll be nice, short. Please. I got a wonderful father. He passed away, but he was a wonderful father. But I got two things from him: my bad bladders and lack of remembering people's names. And I apologize. In all of our meetings, you see me running to the restroom. It's either that or I'm going here, and I don't think you guys want that. So Mr. Guntner, he's the same guy who falsely said I took money from a donor in Glenbrook and falsely said no homeowners associations banned VHRs. He's falsely stating again the purpose of me leaving the meeting. I walked out of the meeting. Dave Nelson's wife wanted to ask me something. I said, I got to go to the bathroom. So I said, walk with me to the bathroom. So she asked me the question why we walked to the bathroom and back. I left public comment during Nancy Gilbert's deal because I've talked to Nancy 653 times, and I think I know everything that she's going to say about public comment. But again, thank you very much, and I want to thank the advisory board. You guys did a great job. Ernie, always a pleasure, and all of the rest of the staff.
So I wasn't sure whether we were done with public comment out there. That's why I was hesitating to. So, but I will. Is there a? And I don't want to invite anybody that doesn't necessarily need to. Okay. Thank you. So, commissioners, anything to add before we adjourn? Commissioner Hales, you're good. Commissioner Noasad? No. Commissioner Rice? Okay. All I wanted to do is, once again, make sure that you understood that the parking permits are back, the barcodes are back on the back table there. Our next meeting is April 20th. That'll be at the Historic Courthouse on 8th Avenue in Minden, and that'll be April 20th, starting at 10 a.m. Other than that, I want to echo the Commissioner's feelings. Tremendous amount of appreciation to the Vacation Home Advisory Board. Extremely critical to us. I know you spent just an ungodly amount of time on this, besides your normal activities of trying to provide or permit permittees. And also, Ms. Casey, really appreciate the Planning Commission's involvement also. Please pass that along to your board. And of course, Mr. Strelo and Mr. Hames and Mr. Delaire. So we look forward to hearing back from you, I believe, on May the 6th. Is that right? Okay. Thank you very much. Stay safe going home. For those of you who live down the hill, be safe. Okay? Thank you.